from here.
That's fine.
I recorded it. I'll just do that. Okay. And Jeffrey, do you have the ballot? I uploaded the ballots. Do you still have access to the new ballot?
Let me check.
Okay. You are now our ballot guy.
Okay.
Carlin, I really liked how you argued about the demonstratives. One thing to think about is when we make an agreement like that, see if you can memorialize it. That was when you write it down on like the back of the form or something. Maybe they'll allow it, maybe they won't, but then you have it in writing.
Okay. But let's say they don't, we can raise a point of order and say, during captain's meeting, this was the agreement and they violated it, so it can't be shown.
I always like when you have it written down. So something to just keep in mind, not a big deal. I'm just waiting for Jeffrey. Jeffrey?
Still working on it.
Oh, okay.
Okay, yeah, I have access to the new ballot.
All right, everybody should have a link to the new ballot. Everybody, please fill out if you're not an active participant in a given round. Feedback is really appreciated for everyone. So I know attorneys won't be able to do it, but and I have given Jesse, he's working on another project also, so he won't be able to add much. All right, anything else before we get to pretrial matters?
No, Your Honor. Defense is
All
ready
right.
to proceed to pretrial.
Okay, prosecution?
Yes, Your Honor. The prosecution is also ready to proceed with pretrial matters.
Okay. Let's begin.
Good evening, Your Honor. Before we proceed with openings, we would like to introduce ourselves. My name is Vanessa Ponte, and today I'm joined by my co-counsel.
Timothy Clemens. Good evening, Your Honor.
And we represent the state of Midlands in today's case. At this time, we'd also like to extend the courtesy of introductions to the defense.
Good evening, Your Honor. My name is Alex Coleman, and I'd also like to, with my co-counsel.
Carlin Carlisi, good evening, Your Honor.
Miguel Soriano, good evening, Your Honor.
And we are the defense in today's trial, and we would like to appoint Dakota Sutcliffe as our party representative for today.
Good evening, Your Honor.
Your Honor, at this time, we would like to ask for your preferences in regards to screen sharing. Should we ask permission before or just demonstrate professional courtesy?
I'd like you to announce that you're going to show it to opposing counsel, have opposing counsel review it, tell me that they've seen it and there's no changes to whatever it is. I assume these are the exhibits. And then you may show it to us, but you may not publish it to the jury, obviously, until and unless it's been admitted.
Yes, Your Honor. And would you like for the timekeeper to put the time into the public chat or privately to the attorneys?
Public chat.
Next, we would like to invoke some rules. First, we'd like to invoke Rule 603, which is the constructive swearing in of all witnesses.
Okay.
Next, we'd like to invoke Rule 615, which is the constructive sequestration of all witnesses, barring the party representative.
Okay.
And finally, Your Honor, as you mentioned, this is a jury trial, so pursuant to 104C, can we assume that all objections are made in a constructive sidebar outside of the hearing of the jury?
Yes.
Thank you, Your Honor. Next, we would like to tender some documents. Constructively tender these documents. The special instructions, stipulations, indictment, motions in limine, character evidence form, Midlands Rules of Evidence, jury instructions, special verdict form, relevant Midlands law, and Midlands case law.
All right, would you put a list in the chat to tell me everything that you just tendered to me?
Yes, Your Honor, I would do that right away. It formatted incorrectly, but I can fix that during the opening. I apologize.
Okay, that's fine.
Finally, the prosecution would like to read some stipulations onto the record.
Okay,
First, we'd like to read onto the record stipulation 9, which states, without conceding whether Jalen Williams was acting within the course of fighting the fire pursuant to Midlands Penal Code 18-402, the parties agree that Exhibit 1 is pre-admitted. Both parties further stipulate that Exhibit 1 may be used during opening statements.
okay. So
Next
why
is-
did you guys not give me the stipulations when you tendered the documents?
That was one of the things we stipulated.
Oh, I see. Yes, I'm sorry. It's in there before the indictment. Okay,
I apologize again. The formatting was strange.
okay.
And then next we'd like to read stipulation 12, which the relevant portion of stipulation 12, which states that if D. Weber is not called as a witness by the state, then both parties agree that exhibits 6A, 6B, and 6C are not pre-admitted. The fire at Chuggy's bar on August 1st, 2020 was man-made, and that paint thinner was used as an accelerant. The prosecution does not plan on calling D. Weber in today's trial. With that, the prosecution is ready to proceed with openings.
Okay, defense.
Yes, Your Honor. The defense would like to tender Midlands Penal Code constructively.
Okay,
And also the defense has one stipulation that I'd like to read onto the record, and that is stipulation 10, that Exhibit 2, the Midlands Department of Health COVID-19 timeline is pre-admitted and both parties may use Exhibit 2 during opening statements.
okay.
And with that, the defense is ready to proceed.
Okay. Anything else, either one of you? Okay, opening statements.
Timothy Clemens for the state, Your Honor. Are you ready for me to proceed?
Give me 1 second to type
course,
in
sir.
notes. I am ready.
Are timekeepers ready to proceed?
Yes.
Your Honor, opposing counsel, members of the jury, may it please the court. At midnight on August 1st, firefighters are rushing out of Chuggy's bar. The sky is blanketed in a veil of smog and soot. As Chuggy's bar crumbles to the ground, firefighter Alex Silva stumbles out of the doorway just inches away before it erupts into a blazing inferno. But members of the jury, you're going to learn that not every firefighter that night was as lucky as Mr. Silva was. You'll learn about firefighter Jalen Williams, who in his last moments was beaten into the ground as the ceiling collapsed above him. They say no man left behind. But on this day, they had no choice. But if that's all this was, if this was just some horrible accident, then we wouldn't be here before you today. You're going to learn that something far worse happened the night of July 31st to August 1st. Both parties have already agreed that this fire was man-made and that it was accelerated by paint thinner. Someone is responsible for that fire at Chuggy's for Jalen Williams' death. And throughout the course of this trial, you're going to learn that there's only one person that can be held responsible. One person who is seen leaving the building the night before. One person who had $1 million to gain and nothing to lose. One person who saw a way out and took it. And that person is none other than the owner of Chuggy's Bar, the defendant, Dakota Sutcliffe. That's why we've charged the defendant with aggravated arson. The law says that no person, by means of fire or explosion, shall knowingly cause physical damage to the structure of oneself with the purpose to defraud. You can't just burn down your own building and expect to be rewarded for it. That's arson. Arson becomes aggravated arson if that fire poses a substantial risk to a person. And we're going to prove that to you today beyond a reasonable doubt. Because when we take a step back and rewind, you're going to learn that Chuggy's Bar was struggling financially. When Detective Khan takes the stand today, we will see a window into the finances of the defendant. Detective Khan will testify that for months leading up to the fire at Chuggy's, the defendant was struggling to make payments on $1 million loan. Detective Khan will testify that after months of begging for extensions, the defendant was told she had to pay up on August 1st. And you're going to learn exactly what the defendant did that day through Harlow's Hardware employee, Kieran Singh, who will testify to seeing Dakota Sutcliffe, the defendant, purchase gallons upon gallons of highly flammable paint thinner. You're going to learn that the night of July 31st, Kieran saw the defendant leave Chuggy's, and only 20 minutes later, it was up in flames. To prove our case to you today, we don't have to prove that the defendant ever wanted or desired Jalen Williams' death. That's not an element. Just that the defendant knew it was a possibility. We will prove that after exhausting all of her options, business failure after failure backed the defendant into a corner. And when that money ran dry, when she got desperate with $1 million on the line, she turned to paint thinner as the solution. It all comes down to this. She saw a way out, and she took it. Find the defendant guilty of aggravated arson. Thank you.
Defense.
Yes, Your Honor. May I proceed?
You may.
May it please the court. Members of the jury, you've just heard from the prosecution, and they started to explain the story that they plan to use to try and prove their case today. But members of the jury, over the course of today's trial, you will learn that this story is nothing but a short-sighted rush to judgment. You'll learn just how short-sighted this story is when you learn who the prosecution is wrongfully trying to blame for this tragedy. The prosecution and law enforcement, in not one but two short-sighted investigations, were quick to point the finger right at a local hero. And you're going to learn all about this local hero, a woman by the name of Dakota Sutcliffe. You'll hear that Ms. Sutcliffe was a longtime volunteer firefighter for our city of Midlands, and that she dedicates a lot of her time to helping others and serving our community. And on top of her selfless service to Midlands, Ms. Sutcliffe was the owner of a local bar. You might have heard of it or even visited at one point. It was called Chuggies. And you'll learn that when Miss Sutcliffe purchased this bar, it was more of an older, dingy dive bar. And like all good owners, Miss Sutcliffe wanted the building to look appealing for guests. So in December of 2019, she started renovations. And all was well until 2020 struck and the world stopped. Everyone's worst nightmare, especially if you were a business owner, was coming to fruition. The COVID-19 pandemic hit and everything was forced to shut down. And you'll learn that, sure, this meant that Miss Sutcliffe was facing a bit of an uphill battle to keep Chuggies alive. And while many businesses, families, and individuals in our resilient city of Midlands struggled at the start of this pandemic, as you just heard, in the prosecution's short-sighted rush to judgment, they plan to villainize Miss Sutcliffe for having to tighten the purse strings a little bit. And there are several things that we, the defense, ask you to keep in mind over the course of today's trial. The first will be this. No matter how the prosecution tries to spin this, struggling financially as a result of the pandemic is not a crime. And as you'll hear from multiple individuals that are called today, such as Tobin Johnson, Miss Sutcliffe never shies away from a challenge and is a very hard worker. The evidence will show that Miss Sutcliffe started to do more innovations to prepare Chuggies for outdoor dining. Chuggies started to do takeout orders in order to give the bar a fighting chance. Miss Sutcliffe took care of all patrons and employees and did everything required of a business owner under the law and then some. Unfortunately, on July 31st, things took a turn for the worse. You'll hear that Miss Sutcliffe left Chuggies after a long day at work and took a walk down at the marina. In order for the prosecution to succeed in their short-sighted rush to judgment, they have to place Miss Sutcliffe at Chuggies in time to set the fire before midnight. But Maddox Vaughn, a regular at Chuggies bar, will take the stand and explain that she also went for a walk at the marina, roughly 60 minutes away from Chuggies, and saw Miss Sutcliffe there at 11:34 p.m., leaving no time for her to make it back to Chuggies to set that fire. Instead, she went down to the firehouse for yet another volunteer shift. The firehouse received a call. Miss Sutcliffe hopped in the truck, and when they arrived at their location, she saw her worst nightmare. Her life's work, the business she was fighting to save, Chuggies Bar, engulfed in flames. To make matters worse, Miss Sutcliffe's childhood best friend and fellow volunteer firefighter, Jalen Williams, wound up dying as Chuggies collapsed in front of Miss Sutcliffe. In just a few hours, everything she knew and loved was gone. And Chuggies and the death of firefighter Jalen Williams were not just big losses for Miss Sutcliffe. They were big losses for our entire community. Investigators felt the heat and the tension across Midlands and needed someone to blame for this tragedy. And in their short-sighted rush to judgment, again, they were quick to point the finger in our direction. But members of the jury, another one of those things you must remember over the course of today's trial is that Miss Sutcliffe is here before you, an innocent woman, and is innocent until proven otherwise. In order for you to find Miss Sutcliffe guilty, the prosecution must prove to you beyond a reasonable doubt that Miss Sutcliffe, by means of fire or explosion, knowingly created a substantial risk of harm to Chuggies Bar, that risk of harm was created with the purpose to defraud, that Miss Sutcliffe knowingly created a substantial risk of harm to another individual, which in this case would be emergency personnel that were in the building that night, and that those emergency personnel were acting within the scope of their duties. And remember, they can't just prove one or two of these. Without proving all of the elements of aggravated arson beyond a reasonable doubt, you cannot find Miss Sutcliffe guilty. And the prosecution simply will not be able to prove all of these elements, because as you will learn from Dr. Maljalani, no one with clear sightlines can place Sutcliffe at the bar before the fire. Moreover, the evidence will show that the investigation into Sutcliffe's finances was incomplete and short-sighted. And it is because of this that at the close of today's trial, my co-counsel Carlin Carlisi will come before you and ask that you find Dakota Sutcliffe not guilty.
Okay, we will proceed as soon as timekeepers say that they're ready.
Ready.
Is
All
the
right.
prosecution timekeeper ready as well?
Timekeepers ready?
Okay. The prosecution calls Detective Norcon to the stand.
Okay.
Hello.
Good evening. Could you please introduce yourself for the court?
Detective Norcon, Midlands PD.
What do you do for a living?
I'm a detective for the White Collar Crimes Division here at the Midlands Center PD.
How are you involved in today's case?
I was tasked with completing a forensic accounting investigation into an incident at the Chuggy's Bar here in Midlands. There was a suspicion of arson. The purpose of my investigation was to see if Dakota Sutcliffe had burned down the bar with the purpose to defraud.
What methods did you use in today's case?
I used something known as a forensic accounting investigation. The forensic accounting method requires analyzing, interpreting, and summarizing complex financial and business matters.
How do you normally apply the principles of a forensic accounting investigation?
Well, let's be honest. There are a lot of terms and contractual dynamics in the financial world that can come off as arcane nonsense. And so when it comes to forensic accounting, in some ways, I'm a translator.
How do you reliably apply forensic accounting in today's case?
In order to apply my methods here, I had to subpoena documents, read all relevant terms, use my expert knowledge to understand their meaning, and lastly, extrapolate the real-world consequences of all of the words on the page.
What documents did you subpoena here?
In this case, I subpoenaed both loan documents as well as a fire insurance policy pertaining to the Chuggy's Bar.
How did you reliably analyze the loan documents and the fire insurance policy for today's case?
I used my expert experience to interpret all of the terms, conditions, and other material facts, one by one, to search for a purpose to defraud. I especially looked into the relevance of furloughs, default or non-payments, lien, and collateral.
You mentioned that you analyzed a loan in this case. What loan was that?
I reviewed the $1 million or so loan documents authorized by Midland State Bank to Sutcliffe for the purposes of renovations at Chuggy's. These include the loan agreement in itself as well as relevant correspondences.
Would you recognize the loan agreement if shown in court today?
Yes.
Objection to 702D, Your Honor, before we proceed with this exhibit.
How so?
Your Honor, if I may direct the court's attention to the orders on motions in limine, Rule 702D, prongs A, B, and C have already been satisfied. However, opposing counsel needs to satisfy prong D in order to properly tender this individual as an expert in today's case. The expert must explain how they reliably apply the methods and principles of their fields to the facts of today's case, which has not been done.
Your response, Ms. Aponte?
Yes, Your Honor. Detective Khan has just finished explaining how he conducted a forensic accounting investigation in today's case and how that requires analyzing, interpreting, and summarizing complex financial and business matters. In this case specifically, he had to subpoena the loan documents and the fire insurance policy, in which he elaborated that he uses his expert knowledge to analyze the terms and conditions of this policy and the loan documents in order to determine whether or not there was any intent or purpose to defraud in today's case. That is more than enough to satisfy 702D, and he should be allowed to be tendered as an expert witness.
May I be heard, Your Honor?
Yes.
Your Honor, if I may direct the court to 702D, the specific wording of this rule states they need to explain how they reliably applied the principles and methods. It doesn't ask what documents they subpoenaed or ask them to go into how they went about the attainment of their documents. It asks how they specifically review these documents. What method did this individual specifically rely on and use when reviewing the documents and looking for fraud? We haven't heard of any specific methods or principles that are both used in the field and were applied to today's case. Therefore, this has not been satisfied.
Your Honor, if
Well,
I may.
No, to put it quite bluntly, like, I don't know if he took these reports and used them as toilet paper. I want to know what he did with these reports, specifically how he analyzed it and what types of principles and methods he used. So I will allow you to lay more foundation. So sustained.
Yes, Your Honor. Detective Khan, what was the specific method that you used in today's case?
So again, in some ways, I'm a translator, and there are a lot of these terms and conditions in the policies that can sometimes be difficult to understand. So furloughs, for example, I had to use my expert knowledge on how these are typically handled out, the typical dates and timelines for extensions that would be given out, the actual meaning of a furlough, and things of that nature. Same goes for default. Not only did I have to come in with my own knowledge of what a default means, I also had to go into the actual document and read the lines one by one and interpret them accordingly. Same goes for non-payment, lien, and collateral. I also had to use some mathematical analysis in my case. This includes things like Benford's law, which is a logarithmic function, and I also had to do a simple interest analysis as well, but those weren't necessary in making my conclusions.
Thank you, Detective Khan. Now, you were discussing prior a loan agreement. Would you recognize that loan agreement if shown in court today?
Your Honor, at this time, I would like to renew my 702D objection if I may be heard.
Well, she is simply showing a document, right? She's not actually, her expert's not being tendered as an expert right now.
Your Honor, I believe that once this document is offered into evidence, the witness would then proceed to discuss what is in this document, which they can only do once they've been tendered as an expert. Therefore, I believe we should have the 702D discussion before it's brought before the court.
Overruled. I believe it's premature.
Your Honor, permission to show opposing counsel what has been purported to be 6B.
What's purported to be 6B?
Yes, Exhibit 6B,
Okay,
prior to showing the witness.
yes.
Opposing counsel, is this okay?
Yes.
Detective Khan, what am I showing on my screen?
This is the loan agreement that I discussed.
And how do you recognize it?
It's one of the documents I subpoenaed.
Is this a fair and accurate copy?
It appears so.
Your Honor, at this time, state moves Exhibit 6B into evidence.
Any objection?
Yes, Your Honor, to hearsay.
Okay, how so?
Your Honor, under Rule 801, hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Here, the prosecution is offering this exhibit for the purposes of going into Ms. Sutcliffe's financials, which goes directly to the intent to defraud, which is would be going directly to the truth of the matter in today's case. This is an out-of-court document being offered for that purpose, therefore it is hearsay.
Your
Ms.
Honor, if I may-
Aponte.
Yes. The state concedes that this is hearsay. However, it is protected under, it is an exception to hearsay under Rule 801 D2B, in that it is an authentic copy, which is signed by the defendant towards the bottom of this page. And so it becomes an opposing party statement adopted or believed to be true by the defendant, by Dakota Sutcliffe affixing her signature. Moreover, this is also an exception to hearsay under Rule 803.15, statements and documents that affect an interest in property, seeing that this document affects the bank's interest in the property, namely Chuggy's Bar, and it goes to establish the money that the defendant owed to the bank. Therefore, it falls under two different exceptions to hearsay, so it is not hearsay.
And anything else, Mr. Soriano?
Yes, as to the 801 D2B, We have not heard any testimony as to what conditions under what conditions this document was signed. Neither of the individuals that were present during the adoption of this document are able to testify in court today. And I apologize. What was the other exception that was offered by opposing counsel?
803.15.
803.15.
Well, let's take those one at a time.
Okay.
Are you indicating that this document right here is not a true and accurate copy of the document?
Not that it's not a true and accurate copy of the document. However, opposing counsel has, through this exception, is stating that the defendant has adopted this as a statement of their own. However, we've heard no testimony as to under what conditions this would have been signed. And if that is true, we simply see a signature, but we've heard no other testimony as to who was present during this. And that is my stance on that exception, Your Honor.
Okay, overruled on that exception. But on the other issue
Yes, Your Honor.
was, yes,
As to the effect on interest in property, we haven't heard any testimony as to how this document is being offered to prove an interest in property. Rather, this document is being offered to show financial undertaking or financial burden being taken on by the defendant. Therefore, this is not being offered to show an interest in property. So that rule under hearsay would not apply.
I agree with you on that, but I'm going to go ahead and let it in because of the first one. So this will be admitted as Exhibit 6B.
Thank you, Your Honor. Now, what about this loan agreement stuck out to you while you investigated?
I'll go over that now. So before I begin analyzing it, there are a number of key definitions I'd like to go over. First, a lender is a party that loans money to another party with the expectation that the loan will be repaid. And a borrower is a party that borrows a loan from a lender and thus owes a debt. Here, going over back to the loan agreement, on the last page, you can see that Kennedy Morgan, an agent from Midland State Bank, signed on behalf of the bank, and Sutcliffe, of course, signed on behalf of herself. Thus, the bank was the lender and Sutcliffe was the borrower. Another key definition is default. A party defaults on its financial contract if the party violates any terms of the contract. Here in page 5 of the loan agreement, you can see the events of default, and one of such events is non-payment. Thus, if Sutcliffe failed to make any payments, Sutcliffe would have been in default of the loan agreement.
Your Honor, at this time, before we proceed, I'd like to re-raise my 702D objection now that we have gone into the actual contents of this document.
Sustained. He doesn't get to go through his analysis of the document. You haven't gotten him tendered as an expert to review his analysis. Is there a further motion you'd like to make, Mr. Soriano?
Yes, Your Honor, I move to strike that testimony before until he is tendered as an expert.
Okay, well, for now, it's stricken. Ms. Aponte?
Yes, Your Honor. Detective Khan, in as thorough detail as possible, could you please explain how you analyzed the documents in today's case?
Yes, again, forensic accounting principles are essentially, as an expert witness, I have duties both pertaining to my duties as a police officer, as well as to my duties as someone who's testifying here today. So I'll stay on to the side of what I'm doing as a police officer and investigator in that account. Forensic accounting investigations are different from an ordinary audit and our methods in that we have a higher responsibility to detect a purpose to defraud than an original audit. And thus, we don't just look through any of the tax records or those exclusively, and we don't analyze the tables as such in a vacuum. We make sure to look through all of the documents and understand how they have real-world consequences and try to take a more realistic and holistic approach to them. And this is pertinent because the documents are essentially the foundation of my investigation and my interpretation of them. And in this specific case as well, I didn't just review the loan agreement, I also reviewed the correspondences. And those correspondences go further into the real world consequences by showing me what actually happened in this scenario and the specifics of it.
Thank you, Detective Khan. At this time, I would like for this witness to be tendered as an expert witness.
Mr. Soriano,
Your Honor, again, all we've heard is discussion of the documents, but what, and he stated that he reviewed these documents, but what specific methods and principles that are used in his field were applied to today's case?
Your Honor, if I may.
yep,
This witness, prior to talking about the loan agreements, explained that he utilized the forensic accounting method, which analyzes any relevant documents, financial documents, in order to understand and interpret for the general public what these documents entail. As he stated, he's essentially a translator of these arcane, as he stated before, arcane words into what actually occurred in today's case. That's why the review of this document does not, the review of these documents is pertinent to his analysis, to his approach, based on his already established expert knowledge in the field of forensic accounting. As such, he has laid more than adequate foundation as to how this witness is an expert.
he's told me that he has an advanced vocabulary, and he's certainly utilizing terrific vocabulary, but I haven't heard any specific methods that he has used and applied, or how he's applied those methods consistently to this information. So, sustained.
Detective Khan, you established prior that, you mentioned prior that you utilized something called the transaction method analysis. Could you elaborate a bit on that?
Yeah, so the transaction method analysis is a subset of forensic accounting principles, and a transaction method analysis that's also heavily based on the documents, but we also make sure to incorporate our own mathematical knowledge as well in analyzing them. So that goes back to the Benford's Law situation that I was mentioning earlier, which we take logarithmic analysis, and that's important as well. If you'd like me to go over the math for that, I could, but
Yes.
it wasn't particularly pertinent in explaining my conclusions here. Also, probably the most important thing in my situation was calculating simple interest and how that plays into this situation. If you look through the actual loan agreement, you can see the principal, the interest rate that was laid out, and the time period for the repayment of the loan. And those are specifically important because that tells me how much money Sutcliffe owed at any particular time as well.
Thank you, Detective Khan. Now, at this time, I would like for this witness to be tendered as an expert witness.
Mr. Soriano,
Yes, Your Honor. This witness just stated that they used something called Benford's Law, but then proceeded to say that that statistical tool was not relevant in reaching their conclusions. Therefore, they're simply throwing at us things that are used in their field, but were not specifically applied in the work on their work on today's case. Additionally, if I may proffer.
nope. Before we get there, I want you to restate it using his gender pronoun. And if you can't, then I'm finding against you.
Did I
You made it.
simply, oh, I apologize. So yes, Detective Khan specifically stated that he applied Benford's Law in today's case. However, he then proceeded to say that it was not relevant in reaching his conclusions on his work on today's case. Therefore, he's simply throwing different statistical tools that are used, however, not stating what specifically was used to reach conclusions in today's case. Therefore, that specific statistical tool would not be relevant in qualifying him as an expert. And additionally, if I may proffer.
Okay.
Okay. Detective Khan did not use Benford's Law correctly in today's case. He did not obtain the proper amount of data that would lead to the most effective analysis. Therefore,
well, we're not even going to go into that. You're saying that Benford's Law doesn't even matter, right, because he didn't use it.
Yes.
Ms. Aponte, did he mention other methods that he used?
Yes, Your Honor, that's what I was just about to say. He mentioned the transaction method analysis, and he explained as to what the transaction method analysis entails and how he applied it in today's case. Now, in addition, as far as the proffer regarding Benford's law, simply is not correct that
I
Detective
don't care
Cohen-
about that right now. So he used the transaction method analysis. Mr. Soriano, did he use that correctly? Do you have anything to say he didn't use it correctly?
I don't have any specific evidence that would suggest he didn't use it correctly. However, it's a very broad analysis. Again, that's simply stating that documents were reviewed,
Your
which
Honor,
kind of leads us back to where we were prior.
if I may,
Okay, Ms. Aponte?
that's simply not true. Detective Khan did explain that the transaction method analysis involves not just review, but analysis of the documents in today's case. The analysis goes towards his expert opinion or his expert experience within the field of forensic accounting and translating what is already in these documents and what he was able to analyze based on the documents that he subpoenaed and his knowledge as an expert witness into what is pertinent for today's case.
Sustained.
Detective Khan, you mentioned a furlough. What is the relevance of a furlough in today's case?
So essentially a furlough is when any payment deadline is moved. Could be relevant to a loan or any other payment that is owed. In this case, Dakota Sutcliffe did receive a furlough, and that's relevant because the due date was allegedly August 1st in my personal review. And it's unclear if Dakota Sutcliffe would have been able to meet the furlough deadline on time.
And what would have happened if hypothetically these payments were not made by the deadline?
So I prepared a flow chart to demonstrate that.
Objection, Your Honor. This witness has not been tendered as an expert, therefore he cannot get into any sort of hypotheticals that as an expert might.
Sustained.
Detective Khan, did you review any other pertinent information in today's case?
Yes, I reviewed a number of email correspondences as well as a fire insurance policy.
Now, can you elaborate as to what your investigation found regarding 5 Point Mutual Insurance Company?
Yes, so Dakota Sutcliffe had taken out a $1.5 million fire insurance policy with the company. And essentially, if the bar burned down, Sutcliffe would hope to collect that money.
Thank you, Detective Khan. No further questions for this witness at this time.
Mr. Soriano?
Yes, Your Honor.
Can I have a minute, please?
Is that the timekeeper?
Yes.
Yes. We'll wait for the timekeeper.
I'm ready.
Okay. Detective Khan, you would be familiar with a COVID-19 government directives timeline if shown in court today, correct?
No.
You would not be familiar with that? Is
No,
that
I
your
would not.
testimony here today?
Yeah, I don't remember it.
Okay, Your Honor, one moment. Moment of the court's indulgence while I prepare this witness's affidavit to be shown before the court today.
Wait, just to be clear, are you discussing the governor's timeline?
That's what I just said, Detective Khan.
Can you display to me?
Display Exhibit 2. So you are familiar with that document?
I can't say for certain I know what you're talking about until I see it, sir.
Okay, now just we will be displaying Exhibit 2 onto the screen. One moment, Your Honor.
May I ask for opposing counsel to show me this exhibit prior?
Let the record reflect that I am now showing opposing counsel Exhibit 2, which has been pre-admitted.
Opposing counsel, could you scroll? Thank you, thank you. This has been
Alrighty,
objections.
Detective Khan, are you familiar with this document?
Yeah, I know what you're talking about now.
Okay. Your Honor, permission to publish to the jury?
Yes.
Okay. Now, Detective Khan, the title on this is Exhibit 2. Sorry, one moment. State of Midlands COVID-19 timeline 2020, correct?
Yes.
Okay, now please follow along as I read aloud. March 15, 2020, Governor Walton issues an executive order closing all non-essential retail stores, bars, restaurants, and prohibits mass gatherings of 10 individuals. I read that correctly, yes?
Yes.
Okay. Now, based on that, Governor Walton's directive would have forced Chuggies to close on March 15th, isn't that right?
Yes.
Okay. Alrighty. And at no point did, before this, did Ms. Sutcliffe miss any sort of payments, isn't that right?
I would say yes, actually.
At no point before March 15th did Ms. Sutcliffe miss any payments, yes or no?
I would like to clarify that she did make all of the minimum payments, but that doesn't
I asked a yes
necessarily
or no
mean she's
question,
on
Detective
track.
Khan.
Could you clarify what you mean by missed payments?
At no point before March 15, 2020 did Ms. Sutcliffe miss any loan payments, yes or no?
I don't understand what you mean by missed payments.
Okay, that's fine. We'll move on. Now, I'd like to read aloud, if you could, we'll scroll down. June 15, 2020, indoor dining and bar patrons allowed if in compliance with CDC precautions. Mandatory 2-week shutdown if COVID-19 positive result by owner, employee, or patron.
I'm sorry to interrupt, but I can't see it. Okay, thank you. Nope.
Okay, well, we're having technical difficulties. So Chuggies was not allowed to serve patrons until nearly 3 months after the first directive, based on that reading that I just read aloud for you, yes or no?
I can see it.
Detective Khan, do you know how many months are in between March 15th and June 15th?
Yes.
3 months, yes?
Yes.
Okay. Now, sorry, one moment. Now you actually reviewed, we can go ahead and take that down. Now you actually reviewed all of the SmartBooks data in your work on today's case, isn't that right?
Yes.
Okay. And you found that all of the revenue was accurately reported, yes or no?
Yes.
There was no evidence of any false reportings, right?
Yes.
No evidence of tax evasion, correct?
Yes.
And you learned that Dakota Sutcliffe might have actually overpaid on her taxes, isn't that right?
It's possible.
Okay. Now, finally, Detective Khan, just to make things very clear for the jury, nothing you reviewed specifically allowed you to specifically and definitively conclude that any sort of fraud took place, yes or no?
Yes.
Nothing further, Your Honor.
Okay. Stop time for just a minute. Zach, pretend to be Norcon for just another minute.
All right.
Mr. Khan, do you know if the bank declared a default on the loan?
No.
No, you don't remember, or no, the bank did not declare default?
there's no evidence of a default. I think that's likely due to the fact that the bar burned down. So there's confusion in the situation.
I see. And do you know if Ms. Sutcliffe has a right to cure?
No, that was not part of my investigation.
All right, so I thought let's go back to the exhibit 6B to section 3.21. You'll note that you said that you were familiar with this document. Is that correct?
6B, yes.
Okay, but you don't see in here that they have that Ms. Sutcliffe has the right to cure any defaults?
That is included in the
Redirected.
document, yes.
3.2.
Yes.
So even though the loan was due, Dakota is in no danger of losing the bar on August 1. Isn't that correct?
There is still a danger because ultimately the bank has a right to take it away.
Oh, right away? On August 1?
No, but at a point later on.
At a point later on, some fixed point, after they declare default, wouldn't that be correct?
Yes.
And after there's a notice of default declared, doesn't Ms. Sutcliffe have time to cure the default?
Yes.
So that's sometime way off in the future,
It's unclear exactly how long.
but certainly not August 1.
That's correct.
Okay. Miguel, I want to see that next time. Okay, timekeepers, are you ready?
Yes.
Okay. Mr. Khan, you may be excused from the bench. Thank you.
Thank you.
I need one more minute. Sorry. Wait, let me go back one more. Okay. Prosecution, do you have another witness?
Yes, Your Honor. The prosecution calls Kieran Singh to the stand.
Okay. And will you be the directing attorney, Ms. Aponte?
Yes, Your Honor. We are
Oh,
short-staffed.
okay. Sorry about that. I was confused. All right, thank you.
Are timekeepers ready?
Yes.
Could you please introduce yourself to the court?
Sup, I'm Kieran Singh.
Where are you currently employed?
I'm currently employed at Harlow's Hardware.
What is your involvement in today's case?
I am the one who called 911 on the night of the Chuggy's fire.
And how do you know the defendant?
I know Dakota from around town. You know, Dakota's the owner of Chuggy's Bar, and she's also a non-volunteer firefighter, and she comes into Harlow's Hardware very often.
What is your relationship with the defendant?
Well, Dakota shops at Harlow's a lot because Chuggy's is in the same lot. Also, I'm gonna be so real with you. I know Dakota personally because I went to Chuggy's once with a fake ID, and let me tell you, Dakota reported it to the police. This caused me to lose my scholarship at school, but I deserved it. It was a dumb college kid move.
Could you please identify the defendant?
Yeah, she's wearing a white jacket, a black shirt, and black hair.
Your Honor, let the record reflect that the witness has accurately identified the defendant. Can you hear me, Your Honor?
Yes, the record so reflects.
Thank you, Your Honor. Kieran, let's discuss the day of July 17, 2020. What were you doing that day?
I was working that day and I heard Dakota Sutcliffe coming into the store. I remember because July 17th is my birthday, and Dakota stood out to me coming into the store. She looked quite upset, and Dakota went into the paint supply aisle.
Objection, Your Honor, to speculation regarding Dakota Sutcliffe looking upset.
Your Honor, if I may.
You may.
Yes, Your Honor. Under Rule 701, the witnesses are allowed to speak to things within their rationally based perception. In this case, Kieran Singh is saying that Dakota looked upset, not that Dakota was upset. Based on his rationally based perception, he is allowed to testify as such.
May it be heard, Your Honor.
Yes.
Your Honor, no foundation has been established to show that Kieran Singh's perception is one that is in fact rationally based, and as such, this witness is speculating.
What was the question?
It wasn't an objection to the question, Your Honor. It was specifically to Kieran Singh stating that Dakota Sutcliffe looked upset.
Your Honor,
Overruled.
thank you, Your Honor. Kieran, did the defendant purchase anything that day?
Yeah, Dakota ended up buying 6 cans of paint thinner, which was about 5 gallons each. So it struck me as odd because I heard that the renovations at Chuggy's have been done since around January 5th, 2020. And also Dakota paid cash.
Objection, Your Honor, to not only hearsay, but also substantially more prejudicial than probative under Rule 403.
Yes. So we're going to take a pause. Timekeepers, go ahead and stop. Jesse's at my office, so I am going to move him very quickly for internet reasons. So let's take a 5-minute break while we handle this. Hey, Jesse. Yeah, we got two.
Oh, wow. It's your sound.
I know, but turn yours off right now. Okay.
Wait, let me. Let me put this right here.
First off, how stable is the connection now?
Well, it's always been 3 bars.
Like, turn off your microphone.
My microphone's off. Because it's not all the way. Sorry. See,
So let's see.
that might not. Yeah, that's not gonna go in. Oh yeah.
Yeah. All right, so let's see if we can get.
Oh, I promise I don't use this. It's just there because I was reading it before.
Recording. All right, so.
No, this is.
That's just a
directed-
Vanessa, yeah. That lets us know if we're still on. Okay, let's turn on your camera really quick.
Well, we're still there.
No, I want to make sure that they can see. Okay, pull up that chair. Put on the side.
Oh, okay.
All right, here's the first question. Can you hear me? Okay, no, keep that off. You're gonna have to speak loud enough, but my speaker's just right there.
Okay.
Okay?
Oh, shoot, this is,
Is that too tall?
no, I should be fine.
Okay, I can move it down further.
No, this is fine.
All right, so can you hear me? Jesse, go ahead and talk.
Hello.
And you can hear Jesse.
Yes.
Okay,
I can barely hear them now.
I'll turn up my sound. Oh, no, that's not it. Hold on. Sorry about this. Okay, all right, so there was an objection,
Two objections, actually, Your
two
Honor.
objections, and I know that Mr. Singh was still talking, but let's go ahead and address the objections. Okay, what was the objection? The first objection.
The first objection was to hearsay, as Kiran Singh stated that he heard renovations were done on January 5th. And then
Sustained.
the second objection was to substantially more prejudicial than probative under Rule 403 regarding Kiran Singh pointing out that Dakota Sutcliffe used cash and that it was odd that she did.
Okay, your response, Ms. Aponte.
Yes, Your Honor, under Rule 403, relevant evidence can be inadmissible if it is substantially more prejudicial than probative. Here in this case, the statement that Kiran Singh found it odd that Dakota paid in cash is substantially more probative because, as if I may proffer, the prosecution will be offering a receipt of this transaction in order to authenticate, and yet on this receipt there is no name. And because Kiran Singh's testimony is important here as to the payment method in this case, because if it was paid in cash, then there would be no specific name, as there was no card or name of a card issued in a case of a transaction.
Okay, so I will entertain a motion to, what was your original question, Ms. Aponte?
I asked, did the defendant purchase anything?
All right, I'm going to strike what was originally answered. I'm going to let you re-ask that question, and we will instruct the witness to answer only that question. And that way we can break it down and have a further discussion.
Before we proceed, Your Honor, could I also raise a motion to strike regarding the fact that Kiran Singh heard that renovations were done, as that objection was sustained?
We're striking everything he answered so that she can re-ask the questions and go through it one at a time. Because I didn't
Understood, Your
hear
Honor.
any of the rest of it because of how it cut out.
Yes, Your Honor.
Okay.
Kiran, did the defendant purchase anything that day?
Yeah, Dakota ended up buying 6 cans of paint thinner, about 5 gallons each. So also, Dakota actually paid cash instead of Dakota's usual methods, which was the business card, which was unusual.
Objection, Your Honor, to substantially more prejudicial than probative under Rule 403 regarding the discussion of cash payment.
Okay, Ms. Aponte?
Yes, Your Honor. As I had stated before, this is to lay foundation as to for a future exhibit that will be admitted in court today, namely the receipt of this transaction, in order to establish that because the defendant paid in cash, there is not going to be a name on this receipt. Therefore, it is more probative than it is prejudicial.
Overruled. I'm going to let you take it up on cross.
Yes, Your Honor.
Kiran, does Harlow's Hardware typically keep a record of all transactions?
Yeah, we keep it electronically and it's automatically generated in our system.
And you ringed up this specific transaction with the defendant?
Yes, I did. I was the cashier.
And there was a receipt for was there a receipt for this transaction?
Yes, there is.
Would you recognize that receipt as shown in court today?
Yes, I would.
Let the record reflect I'm showing opposing counsel what has been purported to be Exhibit 5. apologize. Let me zoom out just a tad. There you go. Now you can see the whole thing. Opposing counsel, is this acceptable? I can't see you on my screen.
I can see it clearly, yes.
Kira, what am I showing on my screen right now?
This is a receipt that I printed out for Dakota's purchase.
And it is a fair and accurate copy?
Yeah, it is.
Your Honor, at this time, State moves Exhibit 5 into evidence.
Any objection?
Yes, Your Honor, I object to both hearsay and I re-raise an objection to actually misleading the jury under Rule 403.
Okay, let's start with how does it mislead the jury?
Your Honor, as you can see on the document, there is no name listed as to who the recipient of the receipt is. And considering prosecution's contention that it was Dakota Sutcliffe, there's no actual evidence to show that the recipient of the receipt was in fact Dakota Sutcliffe. As such, admitting this exhibit with the idea that Dakota Sutcliffe was the one who purchased these paint thinner cans will mislead the jury.
Your Honor, if I may.
You may.
Kieran is currently on the stand testifying under oath that this was the receipt of the transaction that Dakota Sutcliffe made. Opposing counsel is purporting that just because this receipt does not have the name of Dakota Sutcliffe on there, which, might I add, was because this transaction was paid in cash, that because there's no receipt on this, it would mislead the jury as to who the recipient of these paint thinner cans were. Yet Mr. Singh's testimony under oath here is, he is testifying under oath here that Miss Dakota Sutcliffe was the recipient, and this receipt corroborates that fact. Therefore, would not mislead the jury.
And there was another objection, Ms. Carlisi?
Yes, Your Honor, to hearsay.
Okay. How so?
Your Honor, this document is out of court and being offered in court for the truth of the matter asserted, ergo, it is hearsay.
What's the truth that it's asserting?
That yes, in fact, this receipt shows that 6 cans of Skinny's paint thinner was purchased in cash, as prosecution is contending, which is the truth that they are trying to speak to today.
Okay, Ms. Aponte?
Yes, Your Honor. First, I'd like to point out that there's no specific statement being elicited from this as it is a receipt. However, this does fall under the exception of 8036, record of a regularly conducted activity, and therefore is an exception to hearsay.
May it be heard on those grounds, Your Honor?
Yes.
If the argument is that this receipt is meant to be a record of a regularly conducted business activity, then I'd argue that no foundation has been laid to satisfy all 5 prongs of 803 Section 6.
Your Honor, if I may elaborate as to how we've already laid this foundation.
Yes.
Under 803.6a, the record was made at or near the time with by someone with knowledge. In this case, you can see that the date was the date that Kiran Singh reported this transaction to be on July 17, 2020, by Kiran Singh, who would have had knowledge of this transaction, seeing as he was the cashier, which goes towards the prong D of 8036, meaning that he was the custodian of this transaction. That's how we satisfied D. And I already asked Kiran Singh if this was if a receipt is automatically generated in the case of all transactions, to which he answered yes. So that would satisfy that it was a regularly conducted activity of the business and that it was a regular practice of this generator to automatically produce a receipt. And the 5th prong would be E, which is that the opponent does not show the source of information or method of circumstances to indicate a lack of trustworthiness. Nowhere has opposing counsel indicated that Kiran Singh's testimony as to the transaction and the fact that he is the custodian of this transaction will be untrustworthy. Therefore, we have satisfied all 5 prongs, and this is a record of a regularly conducted business activity.
May it be
Ms.
heard, Your
Carlisi.
Honor.
Yes.
Your Honor, considering prong E, no foundation has been laid by opposing counsel, the one bringing forth the receipt in the first place, that this receipt was made with a lack of trustworthiness. Consider, if I may proffer, Your Honor.
Okay,
Your Honor, it will be established that Kieran Singh has a very negative bias towards Dakota Sutcliffe due to the fake ID incident. And as such, considering that there is no name and considering Kieran Singh's bias, there is heavy reason to believe that yes, this document was made with untrustworthiness, and that foundation has not been properly laid. Not only that, per prong C of 8036, it has not been indicated that keeping this receipt is a practice of the business in and of itself. So no, not all foundation has been laid for 803 Section 6, and it must be laid by opposing counsel.
I agree. You haven't met all five prongs of 8036. So at this time it's sustained. I will allow you to lay further foundation.
Yes,
Thank you, Your Honor.
Kieran, is keeping a receipt a regular practice of your business?
Yeah, we print receipts for everything that someone buys.
And finally, did you fake this receipt?
No, I didn't. It was a receipt that was printed out during the transaction.
At this time, State moves Exhibit 5 into evidence.
I'd like to re-raise my objection to hearsay, Your Honor. Prong C of 803 Section 6 has not been properly satisfied.
Your response, Ms. Aponte?
Your Honor, Kieran Singh just testified that not only is making the receipt a regular practice of this business, namely Harlow's Hardware, but that keeping these receipts are also a regular practice of the business. Therefore, prong C has been satisfied.
May it be heard, Your Honor.
Yes.
Your Honor, at no point did Kieran Singh in his answer indicate that keeping the receipt in and of itself is actually a regular practice of the business. And I quote, he said that yes, we print these receipts and printing the receipts is a regular practice. But at no point did he indicate that keeping the receipt, which is what this is, as if I may, this is not the original receipt that was produced by Harlow's Hardware. This was specifically reprinted by Kieran Singh after he went in. So therefore, no, prong C has not been satisfied, and this document is hearsay.
Your Honor, if I may.
Yep.
Prong C states, and I quote, making the record was a regular practice of that activity. In this case, Kieran Singh had testified that the computer automatically generates this receipt as a result of the transaction. Therefore, prong C has been adequately satisfied in this case.
Ms. Carlisi, anything else?
I stand by my objection, Your Honor. Prong C has not been properly satisfied.
I'm going to go ahead and not allow it, so sustained, but not necessarily for all the reasons you guys suggested.
Thank you, Your Honor.
Yes, Your Honor. Now I'd like to move on to the evening of July 31st, 2020. Where were you that day?
On July 31st, 2020, I was at Harlow's Hardware working.
And what happened during your shift?
Around 8 p.m. that night, I was taking out the trash and I saw Dakota throwing these empty cans of paint thinner into the bed of her truck. And these were the ones that she bought from Harlow's. And I thought it was odd because there was a dumpster right next to her. And instead of throwing them in the dumpster, she threw them in the bed of her truck. I went back inside after that to do some work, and Dakota ended up driving away.
And what happened after that?
Around 11:30, I got my shipments from our shipment gal, and I heard a strange noise outside, so I went to check. I saw this dark figure behind Chuggy's, but the figure moved into the light, and we made eye contact, and that's when I realized it was Dakota. I saw parts of her face, and we made eye contact, and the height, the stature, and movements were of Dakota's.
What happened after you saw Dakota?
After I saw Dakota, I went back into Harlow's Hardware.
And after you went into Harlow's, did anything else happen?
Yeah, about 20 minutes later, I smelled a chemical burning smell, and that's when I went to go investigate, and I walked out and I saw that there was smoke pouring out of Chuggy's, and that's when I called 911.
What happened after you called 911?
After I called 911, I gave my statement to Officer Ollie Rodrigo, but I was still processing the events. I saw that a firefighter died in the fire and that it was arson and started by paint thinner. And I realized that only 20 minutes before I spotted the fire, Dakota had left Chuggies and it clicked for me at that point. That Dakota set the fire.
Thank you, Mr. Singh. No further questions at this time.
Are we ready, timekeepers?
One moment.
Okay.
Okay, I'm ready.
Okay, you may begin, Ms. Carlisi.
Let's make this clear, Mr. Singh. You hate Dakota Sutcliffe, don't you?
I dislike her, yeah.
This is because she wouldn't let you drink at her bar while you were underage, right?
Yeah, for the most part.
Now, when this incident happened, as you stated on direct, you had a fake ID with you, right?
Yeah, I did.
And Dakota called the police on you, didn't she?
Yeah, I was the only person that actually I was the only person that she did that to, actually.
Well, let's make something really clear here, Mr. Singh. You were almost kicked out of college because of your incident, isn't that right?
I wouldn't say that. I would say that I only lost half my scholarship.
So you lost a lot of money to be able to continue going to college, isn't that right?
Yeah, but I also had a job, so even if I lost the money, it still would have been plausible.
Well, in that moment, Mr. Singh, after Dakota Sutcliffe caught you with a fake ID, you resented her for it, didn't you?
Yeah, I would say so.
And as such, you've tried to avoid seeing Dakota Sutcliffe at any chance you got. Isn't that true?
Yes.
Well, let's go ahead and talk about a time that you did see her, July 17th, 2020. She came into Harlow's Hardware that day, right?
Yeah.
And she bought some paint thinner from you, didn't she?
Yeah, and she was acting all weird about it too.
Thank you, but back to my question. She bought some paint thinner from you, yes?
Yeah, she bought a lot of paint thinner.
Well, the reason she bought this paint thinner was because renovations were going on at Chuggies, right?
From what I know, I guess.
You've worked at Harlow's Hardware since 2018, haven't you?
Yeah.
And as such, you'd agree with me that you have pretty good knowledge about how certain hardware tools are used, right?
Yeah, and I'm proud of it.
So you'd agree with me that paint thinner is pretty needed for stripping off wood, right?
Yeah.
And it's possible stripping off wood could be part of renovations, couldn't it?
Yeah, Dakota was talking about some of the renovations that they still have to do.
Thank you. Now let's go on to another time you saw Dakota Sutcliffe, July 31st. You saw Dakota at around 8 p.m., right?
Yeah.
And she was disposing of construction materials into her truck, right?
Yeah, which I thought was odd because there was a dumpster next to her.
No, thank you, Mr. Singh, but back to my question. You saw her put construction materials into her truck, yes?
Yeah, which was odd.
Now, you stated on direct that the materials looked like things from Harlow's Hardware, right?
Yeah, I had the same size, same shape. It looked the same. So yeah.
You didn't see any labels on that material, did you?
Not that I can see now.
And you're not 100% certain that those materials were in fact from Harlow's, are you?
I wouldn't say I'm 100, maybe 99.
Despite not seeing any labels on those cans?
Yeah, because they look the same and they look the same size, shape. They looked like the cans that I sold Dakota.
Well, let's be clear about something else you also saw Dakota do. You saw her get into her truck, right?
Yeah.
And she drove away from Chuggy's, didn't she?
From what I saw, she drove away from Chuggy's.
This was around 8:20 p.m., wasn't it?
Yeah,
And at no point did you ever see that truck again, did you?
I didn't see it again, but who's to say that it didn't come back?
Well, back to my question, Mr. Singh, you did not see that truck in the parking lot again after 8:20, did you?
I personally didn't see it, no.
Well, let's go on to later in July 31st. You were there at Harlow's with the purpose of receiving stock, right?
Yeah, from our shipment, yeah.
And that stock arrived at 11 p.m., didn't it?
Yeah, around.
And around 11:15 to 11:20, you heard a strange noise, right?
Yeah, around that time.
So you went outside
That's correct.
and you saw this hooded figure behind Chuggy's, right?
Yeah, which was Dakota.
But back to my question, you saw a hooded figure behind Chuggy's, yes or no?
Yes.
And 20 minutes later, you called 911 because you saw that Chuggy's was on fire.
Yeah, and I noticed that I saw Dakota beforehand under the street lamp, which was very well lit, actually, because we were under a street
Well, we'll
lamp.
get to that, Mr. Singh, but let's be clear about something. After you called 911, you spoke to an officer on the scene, right?
Yeah, I told him about what I saw.
You did? Or is it
I
that
told-
you waited 3 days later to tell them what you saw?
I told them that I saw that Chuggy's was burning down, yes, but I waited till 3 days later to tell them about Dakota because I wasn't 100% sure. But then when I saw that there was paint thinner, I knew that Dakota had previously bought paint thinner, and that also Dakota was the last person to leave Chuggy's.
Well, let's be clear about exactly what you heard that led you to go to the police. You heard the words arson and paint thinner and automatically assumed that Dakota Sutcliffe had something to do with the fire. Isn't that right?
Yeah, because previously, like I said before, she bought paint thinner at
Back to my
Harlow's.
question, Mr. Singh, yes or no? You heard arson and paint thinner and assumed Dakota Sutcliffe had something to do with the fire. Yes or no?
Yeah.
Well, let's go ahead and talk about you seeing this hooded figure. You recall writing on a map the last time you spoke about this incident, right?
Yeah, I do.
And you'd be able to recognize that map if I were to show it to you today?
Yeah, I would.
Your Honor, now sharing with opposing counsel what has been pre-marked. One moment, Your Honor. Oh, what has been pre-marked is Exhibit 30-B.
Looks about right.
Mr. Singh, this is the map in question, correct?
Yes, it seems to be.
It hasn't been changed or altered in any way since you last saw it, right?
No, besides that weird exhibit looking yellow box.
And it's a fair and accurate representation of this map.
Yeah.
Your Honor, at this time, the defense would like to move Exhibit 30-B into evidence.
Any objections?
No objections, Your Honor.
So admitted?
Yes, Your Honor. Let's make this clear, Mr. Singh. You were standing in this circle area, correct?
Yes, I was.
And you'd agree with me that you saw this figure when it was pretty dark outside, isn't that right?
Yeah, but there was a street lamp, and then also the back doors of Harlow's.
Again,
Hardware were
Mr.
actually
Singh,
open.
back to my question. It was very dark outside that night, wasn't it?
Yes, but there was light.
Again, yes or no, Mr. Singh, it was dark outside when you were
Objection
receiving
asked,
stock.
sir.
Your Honor,
Sustained.
the witness is continuing.
Nope, sustained.
You'd agree with me that you were about 40 feet away from this figure, weren't you?
Yeah.
And when it comes to the eye contact, that eye contact actually lasted half a second, didn't it?
Yeah, but that's all I needed.
Half a second was all you needed to properly identify a person's face?
Yep, because I've seen Dakota previously multiple times.
So just to recap, Mr. Singh, You saw a figure in the darkness from 40 feet away for half a second. Do I have that right?
That seems about right.
Thank you. No further questions, Your Honor.
Any redirect?
No, Your Honor, may my witness step down?
Yes. You may be excused.
Your Honor, the state calls Alex Silva to the stand. Timothy Clemens for the state, Your Honor.
Okay. Timekeepers, are you ready or do you need time?
Give me a moment, please.
Okay. Then we're going to take a 1-minute break.
Understood.
Okay.
Good job. Sorry about that.
No, that's really fine. I noticed that too. I was gonna let you know, but I was like,
Are you doing okay during the rest of the time?
Okay, I'm ready.
I can hear everything. But I'm gonna go work on the stuff.
Yeah.
And still stay on this stuff.
Okay. We may begin.
Is Your Honor ready to proceed?
Yes.
Could you please introduce yourself to the court?
My name is Alex Silva.
Mr. Silva, what do you do for a living?
I work full-time for Midlands Department of Parks and Rec since January, but I work part-time with Midlands Center Fire and Rescue Department, where I worked for 8 years.
And why are you testifying today?
I don't want to be here. I don't want to relive this. I was subpoenaed to testify.
Who is Jalen Williams to you?
Jaden Williams was my best friend. I knew him practically my whole life. We grew up as kids in the same neighborhood, and I lost him at Chuggy.
Your Honor, at this time, permission to read onto the record a line from Exhibit 29, the transcript of Ollie Rodrigo.
Any objections?
Sorry, Your Honor. No objections, Your Honor.
Okay, you may do so.
Your Honor, let the record reflect. I'm putting up on the screen Exhibit 29 for authentication purposes. Opposing counsel, does this look all right to you?
Yes, it does.
So I will be reading from lines 134 through 137. Was there any hope of saving Mr. Williams' life at this point? No, ma'am. Due to the fact that Williams' body suffered severe burns after being trapped in the fire, it was clear that he was no longer with us by the time we got to his remains. Mr. Silva, were you with Jalen when he died?
Yes, but I didn't see him. My best friend died, and I don't know why. I don't know what happened. He was there one moment. I turned my back, and he's gone.
So I'd like to talk about that night. When did you arrive at Chucky's?
We received the call and rushed to the scene slightly after midnight. I remember Dakota said another hot night in Midland Center. It's kind of odd. We had to fight the fire internally with a 2-in, 2-out method, and we adhered to it, like our training says.
So you mentioned that 2-in, 2-out method. How did your team go about fighting that fire?
The incident commander chose me and Jalen to be the 2-in. We looked for signs of flashover, which is very dangerous. And then we also had 2 other firefighters, Dews and Sutcliffe, who were the 2 out.
So before we continue, you mentioned Sutcliffe. Who is she?
She was a coworker, a fellow firefighter, somebody who have my back. I consider her a friend. We've worked many shifts over the years.
Would you be able to recognize her in court if I asked you to today?
Yes.
Could you please identify her by an article of clothing, a hair color, or any other notable features?
She's got on a white blazer and a dark V-neck shirt with dark straight hair.
Your Honor, let the record reflect that the witness has accurately identified the defendant in today's case.
Any objection?
No objections, Your Honor.
Okay.
Mr. Silva, would you recognize a photograph of Chuggies if I showed it to you today?
Yeah.
Your Honor, let the record reflect that I'm displaying onto the screen Exhibit 10 for authentication purposes. Opposing counsel, does this look good with you?
Yes, it is fine.
So, Mr. Silva, what have I just put on your screen?
That's the back of Chuggies. That's
Does it
where
look-
we entered.
Does it look to be changed or altered in any way since you last saw it?
No.
Is it an accurate depiction of that location as you remember it?
Yes.
Your Honor, at this time, the state offers Exhibit 10 into evidence.
No objections?
No objections, Your Honor.
And
Okay.
permission to publish to the jury at this time.
Yes.
Oh.
What did you see before you got into this building?
There was all this billowing black smoke coming from the back door. But luckily, there were no cars in the parking lot. It was empty, so we could pull the fire engine right there.
So, moving ahead a little bit, upon entering those doors, what was the fire like?
It was an inferno. The building was quickly going up in flames.
So, where did you two end up going?
First, we went downstairs. You know, the priority is saving lives. We're looking for employees or guests. And then when we didn't find anything, we headed back upstairs.
So, when did it all go wrong?
When we were back upstairs, I wanted to search the bathrooms. I pointed to him. He nodded. I went towards the bathroom, and that was literally the last time I saw my best friend.
Would you recognize the fire code if I showed it to you today?
Yes.
Your Honor, let the record reflect I'm displaying onto the screen Exhibit 9 for authentication purposes. Opposing counsel, does this look all right with you?
Yes, it is correct.
Your Honor, pursuant to the stipulations, this has been pre-admitted. So,
Okay.
Mr. Silva, how do you recognize this?
That's our safety program. Every firefighter in Midland Center has to know this.
And could you please read for us number 2?
Clear, brief, and concise communication is to be used at all times.
Do you believe you did that with Jalen?
Yes.
So, what happened when you were taken outside of the building?
Kelly and Dakota, they literally had to push me out of the building. I was dragged out. I wanted to stay. I wanted that building to burn around me.
And what did Dakota say when you saw her outside?
I was out there trying to get my head, and I saw Dakota pounding on the ambulance. She was crying, and then she looked up at me and started crying too. She said, "I just wanted to make this money
That's
pit
time.
better."
Objection.
Your objection?
Objection to hearsay. Your Honor.
That's right.
Your Honor, may be heard.
Wait, what was your objection? I had a hard time hearing you.
To hearsay.
To hearsay. And what about it was hearsay?
The statement that was being said by Alex Silva.
What was the statement?
It was a statement that that Alex Silva overheard that Dakota was saying at the time when they were outside. I can find the exact wording for you, Your Honor.
May I?
Yes, Mr. Clements.
The statement as elicited was by the defendant. I just wanted to make this money pit better. And if Your Honor would like, I can elaborate on why this is not hearsay.
Yes, why is it not hearsay?
Your Honor, this is a hearsay exemption pursuant to 801D2. Statements by the party opponent, therefore the defendant, are not considered hearsay. Therefore, this is hearsay exempt.
Okay, overruled.
There's no
Judge, that's time.
further questions at this time, Your Honor.
Pardon?
There's no further questions for this witness at the time from the
Okay,
state. Excuse me.
all right, cross-examination.
Yes. Mrs. Silva, you have been with the Midland Center Fire Department for about 8 years now.
That's correct.
And during that time, you met Dakota Sutcliffe,
Of course, yeah.
who has also been a firefighter for about 4 years.
That's about right, yeah.
And you guys have fought multiple fires together.
Of course, yeah.
Okay. And you mentioned that Dakota goes above and beyond.
She does. I mean, I've seen so many above and beyond from her.
And during that time, you had multiple conversations with Dakota.
Yeah, we were coworkers.
And one of those times was when Dakota talked to you about buying a bar.
Yeah, I remember that.
And Dakota also told you about plans to renovate Chuggy's.
Yeah, she wanted to make that money pit something else.
Okay, but then you had to find out that Chuggy's had to close.
Yeah, I mean, COVID hit us all.
Yes, because of COVID.
Yeah, I mean, because of the governor.
Okay. And now onto the night of August 1st, a call came into the fire department.
Correct, yeah.
And that is when Dakota said another hot night in Midlands.
Yeah, when she came through the back door as we were getting ready.
But at that time, you didn't know exactly where you were going.
No, we don't usually find out until we're actually on the fire engine.
Okay. But then when you were on the fire truck, that is when you found out you were heading to Chuggy's.
Yeah, that's when I found out Dakota was right.
Okay. And when you arrived at Chuggy's, you entered through the back door.
Yeah, correct.
And upon entrance, you noticed that the fire was coming from the upper rightmost area of the kitchen.
About there, yeah.
Okay. And then you and Jalen headed downstairs.
Correct, yeah.
And you didn't see anyone.
Nope,
So you headed back upstairs.
correct.
And at this point, that is when you pointed towards the bathroom.
Yeah, because I figured somebody could be in there.
And Jalen gave you a head nod back.
Yeah, simple communication. It's loud in that fire.
Yes, it is loud, but Jalen didn't give much communication back.
Not that I remember. I mean, it might have given a thumbs up or a point, but I don't remember it, no.
Okay. Right after that, you heard a loud crash.
Yeah, the one that took my best friend.
So you came back to about the same area where you last saw Jalen.
Yeah,
And the last thing you saw was Jalen's helmet.
yep, without Jalen.
And after that, Dakota and Kelly Deuce had to pull you out.
Yeah, I would have let that building burn around me.
Okay. And Mrs. Silva, you know that fires are extremely dangerous.
They are extremely dangerous, yeah.
And no one in your workplace would set a fire intentionally.
Objection, Your Honor, to lack of personal knowledge and speculation.
Ms. Coleman?
Your Honor, This is not speculation, as Mr. Silva works at a fire department, so him and his co-workers have personal knowledge that fighting a fire and fires in general are very dangerous. So for a person to commit an active arson setting a fire would lead to no good.
Your Honor,
Sustained.
understood.
Mrs. Silva, you don't believe that Dakota would ever set a fire intentionally?
Objection, Your Honor, to relevance as well as more prejudicial than probative, as well as ultimate issue.
I'm going to allow it.
Yes,
It's
Your Honor.
overruled.
Mrs. Silva, you don't believe that Dakota Sutcliffe would ever set a fire intentionally?
I have a real hard time believing that somebody who I fought fires side to side with could intentionally start a fire. It's just, no, I just can't believe it.
So, Mrs. Silva, that's a no, that Dakota Sutcliffe would never intentionally start a fire.
I don't know what goes through Dakota's mind. All I know is we fought more fires than I can count. And I just can't believe that Dakota would start a fire that would hurt a fellow firefighter. I just can't.
No further questions, Your Honor.
No redirect, Your Honor. At this time, may the witness be allowed to step down.
Yes. Prosecution, any other witnesses?
No, Your Honor. The prosecution rests our case in chief.
Ms. Aponte, are you positive you want to rest your case in chief, or is there something else you'd like to publish to the jury?
At this time, I'd like to publish Exhibit 6B to the jury.
Oh, did that get forgotten earlier?
Yes, it did, Your Honor.
Okay, we'll go ahead and publish that to the jury. Are you going to rest your case now?
Yes, Your Honor.
Okay, how long a break do you guys want?
When is all lost?
Assuming that we started at 7:30, which we did, it should be 10:30.
And then we have a couple minutes because that was my fault for the thing. So just tell me how much time you guys want. You want 5 minutes or 10 minutes?
Can we do 5?
Let's do 5. Okay, see you in 5. Okay, cool, all righty. Hey, Jesse, I like your Apple phone. I'm back, so let me know when you guys are ready.
Excuse me. The state is ready to proceed, Your Honor.
Okay,
Defense is also ready to proceed, Your Honor.
what about those timekeepers? We should be nice to them.
It's just me as a timekeeper, but I'm ready.
I don't know who that was. Oh, Rondé. Rondé, are you
Rondé.
ready?
Yes.
All right, then we're gonna begin.
Your Honor, at this time, the defense calls Maddox Vaughn.
Okay.
May I proceed?
Yes, you may.
Please state your name for the record.
Hello, my name is Maddox Vaughn.
Ms. Vaughn, what is your current occupation?
I'm the lead security officer at the Jaywood buildings. The hours are really rough, but I do love my job.
Ms. Vaughn, why are you here today?
I am here today because Dakota Sutcliffe is being accused of burning down the bar that she owned, Chuggies, but I honestly could never imagine Dakota doing something like that.
Objection, Your Honor, to 403 as well as 703.
How so?
Your Honor, this is unfairly prejudicing the jury into believing that Dakota Sutcliffe wouldn't do this. Purely inflaming the passions of the jury is not allowed under Rule 403. That goes hand in hand with 703, the ultimate issue opinion. It's up to Your Honor's discretion as to whether we can allow ultimate issue opinions in. But there is very little probative value here, and that is substantially outweighed by the prejudicial effect of unfairly prejudicing the jury here. Therefore, it
Mr.
shouldn't be allowed.
Soriano. Ms. Soriano,
Yes,
you gotta
Your Honor.
leave your hair alone. It's just darling.
My apologies, Your Honor. Thank you. Your Honor, we are just about to get into Ms. Vaughn's relationship with the defendant, and an opinion from a lay witness is allowed under Rule 703 as to whether they believe that a certain individual would have committed the act that they're being accused of here today. Ms. Vaughn is very familiar with.
Nope, I'm already confused by your days. So sustained.
Move to strike testimony that Dakota Sutcliffe would not do this.
Yes, granted.
Ms. Vaughn, how do you know? Sorry, Ms. Vaughn, why are you here today?
I'm here today because Dakota Sutcliffe is being accused of burning down the bar that she owned, Chuggies.
And how do you know Dakota?
Dakota and I became pretty close because I spent most of my time at Chuggies. Because of my odd hours at work, Midlands was usually asleep when I was awake and vice versa. Because of this, if I wasn't working or sleeping, I was at Chuggies because it served as my only real social outlet. It was kind of hard for me to make friends at the time. I became a regular and I frequented there so much that my picture started to hang on the wall because I became customer of the month 3 times in a row.
Was Dakota always the owner of Chuggies?
No, the previous owner was Jordan James and Dakota actually bought it in 2019.
And what, if any, changes did you perceive once Dakota purchased Chuggies?
I know that there were plans not only to renovate Chuggies as a whole, but there was a beer garden that was in the works. Dakota thought it would be a nice area for the millennials.
And how was Dakota's work ethic as the owner of Chuggies?
Dakota was very dedicated to her work. Since I was there during the day, I saw the day-to-day operations that went into the place, the opening procedures, the dusting, the cleaning of the tables, chairs, and floors. The place was spotless. And in my opinion, Dakota was putting more effort into the place than it was really worth.
How often would you go to Chuggies?
Quite a bit because of my job. I would say a couple of times a week at least.
And what would you do while at Chucky's?
Have a few drinks, socialize with regulars, the staff, and my favorite bartender and friends, Skylar DeJong.
Now I'd like to discuss July 31st, 2020. Were you at Chucky's that evening?
Yes, I was at Chuggy's for a while before my shift started, and then not long after 9 p.m., I decided to go to the marina for a walk.
What, if anything, happened that night?
Same as usual, really. Chuggy's shut down takeout orders around 9 p.m., and then shortly after that is when I left.
What, if anything, happened after you left the bar?
I had some time before my shift, so I decided to drive down to the marina and take a walk. It was about a 60-minute drive down there.
Did you notice anything while walking at the marina?
Yes, it was about 11:34 p.m. and when I was walking around the marina, I noticed that I saw Dakota. I kept waving my arms at her, but I don't know for sure if she saw me.
And how do you know that this person was Dakota?
I've known Dakota for quite a while now, so when I see Dakota, I recognize her. I've been at Chuggy so often, multiple times a week, so again, I would know Dakota if I saw her, if it was light or dark outside.
Ms. Vaughn, did you have any drinks that night?
I had a few drinks that night, some vodka Red Bulls at Chuggy's and some Emerson whiskey and a beer, maybe 6 or 7 drinks total that night.
And how did these drinks impact your perception of what you saw that night?
Not at all. I've been drinking for many years at this point, so even a few drinks won't affect me as much as they did when I first turned 21. Yes, I had drinks that night, but I was not drunk by any means.
Finally, Ms. Vaughn, do you believe that Dakota has done anything to harm Chucky's?
I do not believe it. Dakota put so much time, energy, and effort. She put her blood, sweat, and tears into the place. I really don't think she could have done something like this.
Nothing further, Your Honor.
Cross. Oh,
Yeah.
timekeepers. Rhonda, are you ready?
Give me a second.
Okay.
Okay, I'm ready.
Okay.
Permission to proceed, Your Honor?
Yes.
Ms. Vaughn, you'd consider yourself a long-time Chuggy's patron, yes?
Yeah, I've been to Chuggy's for a very long time. Again, my picture hangs on a plaque behind the beer taps because I've been customer to them 3 times in a row.
So it's fair to say that you go to Chuggy's often,
Yes, multiple times a week.
several times a week, you
Yes.
said?
Yes.
You were at Chuggy's during the COVID season.
Yes, I was.
You're aware that bars and restaurants were supposed to be closed during the COVID season.
Yes, I'm aware of that because of the mandate, but Dakota was nice enough to let me in because she was sympathetic about my social life and how honestly I didn't have any friends. So
So I want to take a few steps back. Chuggy's, it didn't close, did it?
Chuggy's did close.
Well, that didn't stop the defendant from serving you. Is that right?
Yes, like I said, Dakota was really sympathetic to my situation. And because I wasn't able to get out, she understood that. She let me come in so I could, continue actually speaking to people.
After the mandate, the defendant still served you drinks at her bar.
Yes, just a few drinks. I was going to go thirsty otherwise.
But not just you. The defendant let other people into the bar as well.
I'm not really sure about that.
You don't recall whether or not other people were in the bar?
I know there were the staff, but I'm not really sure, honestly.
Is it your testimony today that you didn't see other customers at the bar?
I'm not saying that it was a definite no. I'm just saying I don't really remember right now.
Okay, so you don't recall whether or not there were customers at the bar.
I really don't remember right now.
Objection asked and answered.
I think she's answered it, so overruled.
So earlier today, you testified that the defendant is a hard worker. Is that right?
Yes, like I said, Dakota puts her blood, sweat, and tears into Chuggy's.
But you don't think Chuggy's is worth all of that hard work. Is that accurate?
Yes, I mean, it's a dive bar that mainly serves college students and old people. So I didn't really think it was necessary to renovate and put all that work into something that was geared towards college students.
In fact, the defendant has said as much, hasn't she?
If Dakota did, it was probably a joke.
The defendant once told you Chuggy's bar would be worth more if it was burned down. Is that right?
Objection to Rule 403, Your Honor.
Okay, how so?
Your Honor, opposing counsel is offering this statement without providing any context as to what was being discussed in the conversation. As this witness previously stated, this could have been a joke, and this would be substantially more prejudicial than probative under Rule 403, seeing as they're offering this for, the truth to say that Dakota did intend to burn down the bar. However, as this witness previously stated, this could have simply been a joke. We've heard no context as to what was discussed in this conversation. Therefore, it's substantially more prejudicial than probative.
Your Honor may be heard.
Yes.
Context and truth are not components of Rule 403. Under Rule 403, relevant evidence may be excluded if its probative value is substantially outweighed by the risk of the prejudicial effect. Here, there is little prejudicial effect, but there is an incredible amount of probative value for the trier of fact to know that the defendant has been thinking about burning the bar down and has even mentioned it publicly before it happened. Therefore, this should be allowed in under Rule 403.
Any other response?
Yes, Your Honor, I maintain my stance that this was a joke, and the opposing counsel is offering this as a truth. Therefore, it is substantially more prejudicial than probative.
Your Honor may be heard.
No, overruled. You may take it up on cross.
So the defendant once told you Chuggy's bar would be worth more if it was burned down.
No, I don't recall that.
You don't recall that statement.
No.
Is it? Okay. So I'd like to talk about what you did on July 31st. You'd agree with me that that's the day before Chuggy's bar burned down.
Yes, Chuggy's burned down on August 1st. So yeah, July 31st was the day before.
Actually, I'd like to circle back. You mentioned you don't recall whether or not Chuggy's bar would be worth more if it burned down. You don't recall hearing that from the defendant?
I can't remember.
Would you like your memory refreshed?
Sure.
So, brief court, seems my co-counsel has pulled it up. Would you recognize your affidavit if shown in court today?
Yes.
Your Honor, let the record reflect that I'm displaying onto the screen the affidavit of Maddox Vaughn for authentication purposes. Is that all right with Your Honor? Is that all right with Your Honor?
So yes.
Oh, does that look all right, opposing counsel?
Yes.
So this is your statement, is it, Maddox Vaughn?
Yeah, that's my signature.
And it doesn't look to be changed or altered in any way since you last saw it.
I don't think so.
So brief moment, the court's indulgence. Oh, yes. So do I enlarge this? There you go. Okay. So please read along silently as I read aloud. I'll be referencing lines 47 and 48. Once Sutcliffe even joked that it probably would be easier to torch the place than to start over and renovate. Does that sound familiar to you?
Yes, that does sound familiar, but the question you asked me was, did Sutcliffe once say that the bar would be worth more if it was burned down? And that's different from what I have here. And I also said it was a joke because that's exactly what it was. Sutcliffe was joking.
So she joked that she would torch the place down. Is that right?
Yes, she joked.
Joking about burning the building down.
I mean,
Objection asked and answered.
Your Honor, that's not the same form.
Overruled.
She joked about burning the building down.
She's a volunteer firefighter, so it's not weird for her to make arson-related jokes.
Regardless or not, if it was weird, she did joke about it. Is that right?
I just answered yes.
Okay. And moving on to the night before the fire, that's July 31st. Is that accurate?
Yes.
And the day before Chuggy's burned down, you were at Chuggy's.
Yes, I was. Same as usual, just, hanging out before my shift at Jaywood.
At Chuggy's, you were drinking alcohol.
Yes, I had 6 or 7 drinks total that night.
So I'd like to walk through all of those drinks. You had 2 beers at Chuggy's.
Yes, 2 beers and a vodka Red Bull at Chuggy's.
Then you had that vodka Red Bull at Chuggy's, yes?
Yes.
And you left Chuggy's bar at 9 p.m.
Shortly after 9.
You'd agree with me that you've been drinking for an hour and 15 minutes at that point?
Yes, but it really hadn't affected me that much.
After drinking for an hour and 15 minutes, you went to your car.
Yes, I got in my car and I drove home.
After drinking for an hour and 15 minutes, you drove all the way home?
Yes, I drove home.
And when you got home, you continued to drink?
Yes, I had 2 more vodka Red Bulls and a shot of Emerson whiskey at home.
And then you got behind the wheel of your car and went to the marina, is that right?
Yeah, I like to take walks around the marina before my shift to clear my head. And I had some time, so I figured why not?
That took about till 11:30, is that right?
Yes.
So you've been drinking for more than 2 hours at this point.
Yes, it had been a couple hours.
And you were still drinking while you were at the marina?
I just took 1 or 2 swigs from my flask, but nothing much.
From a flask filled with whiskey?
There was just a little bit of whiskey in it. It wasn't that much. Again, 1 or 2 swigs.
Okay. But you were still drinking while you're taking that walk, is that right?
Yes, I just said I was drinking when I was walking around the marina.
And at 11:30, you claim you saw someone you purport to be the defendant.
I know for a fact that I saw Dakota at the marina that night.
You don't believe alcohol affected you?
No, I've been drinking for a very long time, so I've gained a tolerance to it. It's been a long time since I've turned 21. So again, it doesn't affect me as much as, my college days.
Yes or no? You were buzzed.
Buzzed, but I was not drunk.
Okay, so the alcohol was affecting you in some capacity.
Yes, but it didn't change my perception of what I witnessed that night.
All right, Mrs. Vaughn. You're confident that that person was the defendant?
I'm positive it was, yes.
You're confident, even though it was dark outside?
Yes, but the marina is actually very well lit, so it's basically like daytime.
You're confident, even though you saw this person from 70 feet away?
Yes, I see Dakota practically on a daily basis. So when I see Dakota, I recognize Dakota.
You're confident, even though you waved and this person didn't wave back?
Yeah, I waved at Dakota, and although she didn't see me, I definitely saw her.
You're confident, even though you never walked up to confirm?
No, she was too far away, but again, I know for sure it was Dakota.
You're confident, even though you never spoke with this person?
No, but I did wave my arms at her.
Nor did you hear her voice?
No.
All of these things, and you never once doubted your identification. Is that
No,
accurate?
It is accurate. I'm positive the person I saw that night was Dakota because I'd recognize her from a million miles away.
Right. No further questions for this witness from the state, Your Honor.
Any redirect?
No redirect, Your Honor.
Okay,
May this witness be
Next.
excused.
yes, next witness.
Your Honor, at this time, the defense calls Dr. Mel Jelani to the stand. Before I proceed to the direct, Your Honor, if I could invite the court's attention to the orders on motions in limine,
Okay,
specifically to the Tarot Readers Association ruling. Prong A, B, and C of 702 have been satisfied prior to this trial. As such, adequate foundation will be laid to satisfy prong D of 702.
okay.
Our
Any
timekeeper is ready
comment?
to proceed.
Any comments on that? Who's the prosecuting attorney? Ms. Aponte?
No comments, Your Honor.
Okay,
Is the timekeeper ready?
Yes, I'm ready.
Please state your name for the record.
Dr. Mel Jelani.
What is your involvement in this case, Dr. Jelani?
I was hired by the defense to evaluate the statements from Kieran Singh and Maddox Vaughn in regards to the potential identification of Dakota Sutcliffe on July 31st, 2020.
Now, what exactly are the circumstances of your investigation?
Well, I reviewed the statements, evaluated their eyewitness recollection, and prepared my report for a total of 60 hours. I charged $350 per hour of review and analysis, as well as a rate of $10,000 for trial testimony.
What exactly did you review when evaluating these eyewitness testimonies?
I reviewed the visual perceptions and memory translations within the vision to memory process. I also reviewed the affidavits of Kieran Singh and Maddox Vaughn.
Dr. Jelani, how do you typically evaluate eyewitness testimony?
I evaluate eyewitness testimony using the stages of visual processing and memory translations, using peer-reviewed studies such as Melton's 1963 study on memory and visual processing. As well, my education, where I was certified in forensic psychology and as a result was taught to apply these stages in my evaluation.
What exactly are the visual processing stages?
I actually made a guide on that. That would be rather helpful if you would like me to pull that up.
Your Honor, permission for the witness to make use of a demonstrative?
Yes.
So this is a diagram of the eye, as well as the photoreceptors located in the back of the eye. There are three stages to visual processing. There's sensation, attention, and perception. Sensation is where the light enters the eye, moves through the lens, and is received by the retina where the photoreceptors are activated. Imagine this green arrow is the light that enters the eye. It will pass through the lens and hit the back of the eye, the retina, where photoreceptors perform their function. As shown here, there are two types of photoreceptors. There are cones and rods. Starting off with rods, rods work best in, well, poor lighting. And they make the eyes more sensitive to movement, but it also makes the eyes less accurate with what it is perceiving. Cones perform their function best in good lighting, and they can reveal full color and detail. You have attention, which is the second stage, where focus is a key factor. The observer selects what they wish to pay attention to, for example, with a magic trick. The magician might prepare a trick on one end of the table when the observer is focused on another end of the table. And then finally, you have perception. This is where the visual information is made to be coherent by the brain. But perception can also be impacted by bias. This rope might look like a snake to some people, might look like a hose to others, and it might look like a rope. It is based upon the person's previous experiences that they come to the conclusions of what it is that they have just perceived. And I will remove this now.
Thank you, Dr. Jelani. You also mentioned memory creation. What exactly are those processes?
There's also three stages here: encoding, storage, and retrieval. Encoding is the initial process where information is placed into short-term memory. Storage is where long-term memory comes in, and retrieval is where the information is being recalled back into existence by the observer.
Now, how did you reliably apply those processes to the statements you reviewed in this case?
With these statements, I applied the stages by examining the witness's sensations, their focal points, the integration of visual information, as well as their encoding process, the storage and the retrieval processes to see if there was any indications of alterations.
You just mentioned alterations. How does that play a factor in these processes?
Well, noise or distracting factors can come into play and alter any of these processes.
How can noise alter visual processing?
Primarily by light, oftentimes by angles and by bias as well.
And how does noise affect memory creation?
Memory can be altered by alcohol consumption, bias, intrusions, or suggestions even.
Were any of these alterations you just mentioned present in the statements you reviewed?
Yes, I saw them in both Kieran Singh's and Maddox Vaughn's statements.
Well, let's talk about your review of Kieran Singh. What exactly were the key points of his identification?
Kieran believes he saw Dakota Sutcliffe on the night of the Chuggy's fire. Kieran believes so because he saw a hooded figure that he made eye contact with for about half a second.
Was there anything else you reviewed beyond Kieran Singh's own testimony?
I reviewed a layout of the parking structure that was annotated upon by Kieran Singh.
If I were to show you those annotations, would you be able to recognize them?
I would, yes.
Your Honor, now showing opposing counsel what has already been entered into evidence as Exhibit 30-B.
Okay.
Dr. Jelani, are these the annotations in question?
Yes.
Have they been changed and altered in any way since you last saw them?
No.
Is a fair and accurate representation of those annotations you reviewed?
I would say it is, yes.
So, what noise was present in Kieran Singh's identification?
Well, it was indicated that there were two primary sources of light. As seen in here, it would be the triangles. The light source was diagonally placed, which could have had a large impact on Kieran's perception, as not only was the area dark at the time, but diagonal lighting can affect a person's ability to properly process the light within the photoreceptor cells. A person's peripheral being affected by a diagonal light source can make for noise. Light is the first and most important factor in sensation. And not only was there a lack of light, which can compromise the other visual processes, but Kieran also saw this figure from a distance, specifically 40 feet away.
Your Honor, let the record reflect the markings currently made on Exhibit 30-B, the circle over the triangle, the line that points to light at an angle, as well as the line that indicates the 40-foot distance and the text stating there within.
The record may so reflect.
Dr. Jelani, you also mentioned that Kieran Singh saw this hooded figure for half a second. How does that time frame affect the impact of what he saw?
Well, Kieran saw this figure for half a second, which in dim lighting could impact the sensation of his vision process. It's not an ideal time span to properly recognize one's facial features. I also have another guide for this, if you would like to show it.
It's currently shown, Dr. Jelani. Now, how does someone see half a second of a person?
It isn't idealistic, but this would hypothetically be how long Kieran saw the figure for.
Now, let's move on to Maddox Vaughn. What were the key points of her identification?
Maddox saw a person at the marina on the night of the fire that looked like Dakota Sutcliffe. The level of illumination was indicated to be high, and Maddox had a personal knowledge of Dakota from day-to-day interaction. Maddox had also interacted with Dakota on the night of prior to this perception.
What noise was present in Maddox's identification?
Maddox had consumed alcohol the night of. That being said, I do not have reason to believe that the alcohol had a particularly strong impact on Maddox Vaughn.
Why don't you think the alcohol consumption had a strong impact on what Maddox Vaughn saw that night?
When someone is a frequent drinker, their ADH levels are increased. ADH is alcohol dehydrogenase, and it is an enzyme within the liver that processes alcohol and actually gets rid of the alcohol from the system.
Objection, Your Honor. Improper expert opinion.
Okay, how so?
Your Honor, this witness is testifying to the biological impacts of alcohol. Seeing as Dr. Jelani is a forensic psychologist, this is outside the scope of her expertise, and as such, she should not be able to testify on this matter.
Your response, Ms. Carlisi.
Yes, Your Honor. The reason Dr. Jelani is speaking on how exactly alcohol affects the body is, as she stated earlier, alcohol consumption can be a way that alterations are present in what a witness perceives to be what they saw. Dr. Jelani is not speaking as someone as an expert with an expertise in alcohol and biological transferring of alcohol. She is specifically speaking to the relevant information regarding exactly how alcohol consumption affects witness perception, which is in line with her expert testimony under Rule 702.
And any other response, Ms. Aponte?
Yes, Your Honor, as I stated before, this witness is getting into biological processes of how ADH levels impact or alcohol consumption impacts ADH levels, and that is outside the scope of forensic psychology and therefore outside the scope of this witness's expertise.
Okay, overruled.
Would you like me to re-ask the question, Dr. Jelani?
Yes, please.
Why exactly are you not concerned with Maddox Vaughn's alcohol consumption in relation to what she saw that night?
When somebody is a frequent drinker, their ADH levels are increased. Maddox Vaughn has indicated that she drinks quite often, rather daily even. And because of this, ADH is the enzyme that is located within the liver that essentially cleanses the body of alcohol. And Maddox would likely have an extremely high level of ADH, therefore the encoding process would not be as affected.
Ultimately, Dr. Jelani, are there enough indicators to say that Kiran Singh's identification of the hooded figure is completely reliable?
Well, quickly addressing bias, which is one of the things that could have impacted it, Kiran has indicated that he has a strong bias against Dakota. And due to large indicators, it can be an altering factor because the perception process usually shifts with bias. We usually come to our conclusions on what visual information means, and because Kiran came to the police with an additional statement only after having heard about arson and paint thinner on the news, the process of retrieval and storage makes our minds malleable. As such, this suggestion could have altered Kiran's memory. With that, I would say that while there are certain factors of Kiran's identification that cannot be ignored, it doesn't mean that the identification is completely reliable.
And are there enough indicators to say that Maddox Vaughn's identification of Dakota Sutcliffe at the marina is reliable?
While the circumstances Maddox was in may not grant the identification as 100% reliable, no identification ever really is, but it is still possible that Maddox did see Dakota at the marina that night.
Thank you, Dr. Jelani. No further questions for the witness.
Any cross?
Yes, Your Honor, timekeeper's okay for me to proceed?
One moment. I'm ready.
I apologize. Give me 1 second as I'm plugging my computer in so it does not die.
That's a good idea. No problem.
Okay. All right. It's plugged in. Shows up at 3% and I'm like, okay. All right. Dr. Delani, you mentioned on direct that you're being paid $10,000 by the defense for your testimony here today. Is that true?
That would be the average price for my line of work, yes.
And that's what you're being paid to testify today?
Yes, which is the average rate in my line of work.
And it's also true that within your line of work, you are hired by the defense in about 70% of the cases you undertake?
I am.
And so would it be accurate to say that your practice is more defense oriented?
No, I don't reject clients based upon their party. I would willingly take a prosecution party as well. It's just defense parties come to me more frequently.
And now I'd like to get into your analysis of this case in particular. You never personally interviewed Kiran Singh.
I did not. It was not necessary, no.
You didn't interview Maddox Vaughn either?
It was also not necessary. It could have compromised their retrieval processes within the memory translation process, so I did not do that for any of the witnesses.
So just to make it clear, you deemed it unnecessary to interview the witnesses whose accounts you were trying to analyze for reliability?
So let me explain to you the retrieval process really quick. It is
Dr. Delani, I just wanted to get a yes or no. You deemed unnecessary to interview the witnesses whose accounts you were analyzing for reliability?
I deemed it so because it could have compromised their memory processes. Yes.
Thank you, Dr. Jelani. And as far as, or in regards to your analysis of this case, you also didn't personally visit the area behind Chuggy's bar to observe the lighting from the street lamps?
Objection, Your Honor, to relevance.
Your Honor, under Rule 1, evidence is relevant if it is both material and probative. Here, this question speaks to whether or not Dr. Jelani personally went and visited the site in which she is claiming, making claims regarding the angles, regarding the testimony of Kiran Singh, and it makes it less likely that her analysis is reliable, considering that she didn't personally see just how much those street lamps illuminated the area.
May I be heard, Your Honor?
Yes.
Your Honor, per the orders on motions in limine, prong B of 702 has been satisfied prior to today's trial, and prong B in specifics is sufficient facts and data. What that means is that the court has already agreed that what Dr. Jelani reviewed is sufficient enough to come to her conclusions. Not only that, but in terms of reliability, Your Honor, at no point during the direct examination did opposing counsel have any issue with the foundation laid, and as such, Dr. Jelani was properly qualified as an expert, meaning that her methods were reliably applied and the information she used was reliable. As such, this line of questioning is irrelevant.
Your Honor, if I may.
You may.
The reason that I did not object prior is because this is an issue for cross-examination as to just how much Dr. Jelani actually analyzed within her analysis of this case. As far as the issue of whether or not Dr. Jelani did utilize sufficient facts and data, that is agreed upon under the orders on motions in limine. However, this doesn't necessarily go towards saying that she didn't review sufficient facts and data, but just rather that the alleged sufficient facts and data she did review were not all encompassing.
Sustained.
Motion to strike the line of questioning, Your Honor?
No, just this last question.
Yes, Your Honor.
Now, Dr. Jelani, let's dive into Singh's account first. Now, you gave an expert report regarding your analysis for today's case, right?
I did.
And that report contains all the pertinent information from your analysis?
It would, yes.
And yet you never in your report state anything regarding the unreliability of light angles behind Chuggies. Is that correct?
Are you asking whether my conclusions were based upon, are you asking whether I included the science that my conclusions were based upon, or are you asking about the witnesses' accounts in particular?
I'm asking you, did you include in your report anything about a factor of unreliability being the angle at which the lights came through behind Chuggies for Singh's account?
I indicated within my report that light was a large factor that could have caused alterations.
But there was nothing regarding specifically that the angle of light would be an issue.
I did state that angles would be an issue within the sensation process. I didn't write particularly that the angle by which light was. I do believe that that is sort of a conclusion that can be placed upon this, as light and angles sort of come hand in hand within the vision process.
Yes, but just to clarify, that was not explicitly stated in your report.
Objection, Your Honor, to asked and answered.
This witness has not yet answered as far as whether this was explicitly stated in the report.
May I be heard, Your Honor?
No, I'm going to say asked and answered, so sustained.
Thank you,
In
Your
fact,
Honor.
Dr. Jelani, oh, I apologize. In fact, Dr. Jelani, it's true that some aspects of Singh's recounting of events show a high likelihood of reliability, right?
There were aspects within all the witnesses that showed a certain degree of high reliability, yes.
And specifically for Singh, Singh saw the defendant in the light behind Chuggy's shortly before the fire, didn't he?
Singh saw a hooded figure that he believed to be the defendant for about half a second.
And this eye contact was without any distractions.
I would say that there were indicators of alterations. If you're talking about physical obtrusions, no.
And there was no visual overload either.
Not ones that I did not mention, no.
In fact, Kiran Singh was the only witness you analyzed who made direct eye contact with the defendant. Isn't that correct?
Who believed so, yes.
And as you stated earlier, this eye contact was short, but let's be clear, Singh does know the defendant, isn't that right?
I would say so.
And Singh has had prior interactions with the defendant.
I believe all the witnesses I analyzed had prior interactions with the defendant, yes.
And specifically with Singh's prior interactions with the defendant would make it so that Singh could positively identify the defendant even after a brief second of eye contact?
I would not say that it is an idealistic time. I would say it is a possibility.
But it is your expert opinion that Singh's identification of the defendant behind Chuggy's on the night of the fire cannot be ignored or discounted.
None of the witnesses' statements can be ignored or discounted, no.
And this specific identification cannot either, right?
The witnesses' believed perception cannot be discounted, no.
Now let's discuss Maddox Vaughn. In your report, you do discuss the effects of alcohol on memory, right?
Yes.
And now specifically, you state that if a person defines themselves as buzzed, they lose the ability to encode all facets of an experience or an event. Is that correct?
It is highly likely that that is the case. However, it does vary from person to person. Everyone's tolerance can be different.
And yet, you never state in your report that Maddox's tolerance would lead to a higher reliability of this identification.
As I've explained with the previous question, everybody's tolerance is different. So coming to my conclusions based upon the ADH levels or potential enzymatic processes within the human body, I would say that it is possible that Maddox could have seen Dakota Sutcliffe.
Even though that you're aware, Maddox Vaughn described herself as buzzed the night that she allegedly saw the defendant.
At one point, however, Maddox also indicated that she is a frequent drinker and that the alcohol doesn't affect her as often.
Not only that, but Maddox Vaughn allegedly saw the defendant from a distance of 70 feet. Is that right?
Yes, at the marina.
And Maddox never spoke to the defendant, did she?
Not that I'm aware.
Nor did she ever get an indication that this person actually recognized her.
Are you talking about the entirety of the night, or are you talking about just the encounter at the marina?
Just the encounter at the marina.
Then no, I'm not aware of.
And it is your expert opinion that there is a high likelihood that Maddox's identification of the defendant may not have been encoded accurately into her memory. Isn't that right?
There's a possibility if the alcohol truly did impact her memory.
Thank you, Dr. Delaney. But back to my question, it's a high likelihood. Is that not correct?
It is a possibility, yes.
Again, back to my question.
Objection, Your Honor, to asked and answered. The witness has said yes to this question.
Sustained.
Thank you. No further questions for this witness at this time.
Any redirect?
No redirect, Your Honor. May the witness be excused?
Yes. Do we have another witness?
Yes, the defense calls Tobin Johnson.
Okay, we're gonna give the timekeeper a minute, and once the timekeeper tells us, then we should be good to go.
I'm ready.
All right, I take that back. Give me another minute to type in. Okay, now I'm ready.
Okay. Good evening. Can you please state your name for the record?
My name is Tobin Johnson.
Can you tell us a little bit about yourself, Ms. Johnson?
Sure. So before the fire that happened at Chuggy's, I was a host and a server there, as well as a delivery driver. And I'm here today because my former boss, Dakota Sutcliffe, is being accused of burning down Chuggy's, which I just think is ridiculous. But
Where have you previously worked?
well, I've been with Chuggy since 2017. That was back when the original owner was Jordan James. I'd say my employment lasted about 3 years or so because unfortunately, like I said, the bar burned down in 2020.
When did Dakota Sutcliffe take over?
About a year or so. He bought the business from the original owner, like I said, Jordan James, and that was in 2019. And there's been quite a lot of changes since then, let me tell you.
Can you tell us a little bit about those changes?
Yeah, so Jordan as an owner was pretty lax. We were allowed to get away with a lot of things. Like we let a lot of people under the age of 21 into the bar, and we really didn't follow a lot of fire code. We kind of just packed a bunch of people in there. But since Dakota has taken over, she's been a lot more strict, and the cleaning procedures have been up, and we are no longer violating fire code or letting people under the age of 21 in.
Okay, and how did Dakota act as a boss?
Like I said, she was a great boss. She followed protocol. She kept everything up to standard, and she treated the employees very well. I didn't really have any complaints.
Okay, and did Chuggy's go under any renovations?
Yes, Dakota decided in November when business was doing really well that she wanted to go ahead and do some
Objection,
renovations.
Your Honor. Lack of foundation as to how this witness acquired the personal knowledge of what Dakota thought, as this line of testimony is starting to tread into the realm of speculation.
Sustained.
Yes, Your Honor. When was Chuggy supposed to open back up?
We were supposed to open back up for New Year's Eve as we were closed for renovations during that time. But unfortunately, due to delays in that, we were not able to open until January 5th, which was a pretty big blow for Chuggy's because we usually make a lot of money on New Year's.
Okay, and how was Chuggy's after the renovations?
It was all right. It helped that we had the college kids that were back in town, which makes up a lot of our patrons, but we still struggled a little bit. And then unfortunately, due to COVID, we were forced to close down.
How did COVID affect Chuggy's?
It was pretty rough. We were closed for that period of time. And during that time, Dakota had wanted to try to bring in some income where she could.
Objection, Your Honor, to lack of foundation as to how she acquired that knowledge.
Sustained.
Your Honor, do you want me to lay that foundation?
You may lay that foundation.
Okay. Were you still employed when Chuggy's was closed?
Yes, I was.
Okay, and what were your duties?
Because we were closed due to the pandemic and we weren't allowed to have people come in, Dakota decided to try to bring in some extra income. So I became a delivery driver.
Objection, Your Honor, to lack of foundation as to the defendant's business plans.
Sustained? You may lay that foundation?
Your Honor, may I be heard?
No.
Okay. Ms. Johnson, did things ever improve with Chuggies?
Eventually, the governor announced that bars and restaurants would be able to open on May 15th, as long as there was outdoor seating with social distancing that was maintained. But unfortunately, because the back patio wasn't done yet, we really couldn't partake in that. People eventually came back to Chuggies in late May, but it never hit the pre-pandemic levels. And it took about until July until things really started to pick back up.
So what exactly happened in July of 2020?
Well, business was picking up somewhat. Some of our regulars were coming back, and we were doing all right. But unfortunately, on July 15th, our cook ended up coming down with COVID. He tested positive, and so unfortunately, we were forced to shut down for 2 weeks, and then we were able to open up around the end of July.
Okay, I want to talk just a little bit more at the end of July. On July 31st, what did you do that day?
Well, it was around noon and it was just a regular day. I came in for my shift as usual to get ready for the evening. And I'd seen that there was an order of paint thinner that had come in from Harlow's Hardware. And so I went to Dakota and I asked her what she wanted me to do with it. And she said to put it in her office. And she was really excited because she said we'd finally be able to finish the renovations made for the patio.
And what did this mean for Chuggies then?
That would mean at that point that we'd be able to finally be able to function at full capacity with having that outdoor seating, and we would be able to start making up for a lot of the revenue that we lost during COVID.
And how was the rest of that evening?
Like I said, it was just a normal evening. I was doing my deliveries, and as I came back from that, I saw that Dakota had moved the boxes into the basement and was preparing that. And unfortunately, at that time, one of our regular patrons had let us know that they too had tested positive for COVID, which of course meant that we needed to close again. And Dakota was just devastated.
Now, Ms. Johnson, how did you learn about Chuggies being burned down?
I only learned about it when I saw it. I came in for my shift that morning on August 1st, and I saw that the roads were blocked off. There was fire trucks and first responders and just a lot of commotion, and I wasn't sure at first. But when I got close enough to downtown Midland Center, I could see that Chuggies had burned down and it was completely destroyed. And it was just so awful to see because Dakota has put so much work and time and energy into Chuggies, and we all love Chuggies. And to see everybody turning on Dakota now and pointing their finger at her, the whole thing is just short-sighted.
No further questions at this time, Your Honor.
Okay. We'll wait for timekeeper.
Yes, sir. Is the timekeeper ready to proceed?
Yes.
Thank you. Your Honor, are you ready for me to begin?
Yes.
Timothy Clemens for the state, Your Honor. Ms. Johnson, You consider yourself loyal to Chuggies, is that right?
That's correct.
You've worked at Chuggies for around 4 years, is that accurate?
Yes.
But not currently.
No, not currently. There's no bar to work at.
You want to go back to Chuggies, is that accurate?
It would be ideal.
In fact, the defendant offered you a job once Chuggies reopens.
That's correct.
You consider yourself a good friend of the defendant.
I consider myself a good friend, period.
She would confide in you about the finances, yes?
From time to time.
I'd like to talk about one of those occasions. In November of 2019, the defendant told you the defendant was going to renovate Chuggies Bar.
That's correct.
She said, I've cleared out all of my savings. Is that right?
Yes,
She said, I've got $1 million loan from the bank.
that's correct.
And over the course of several months, like you mentioned, those renovations did happen.
Yes,
In fact, you participated in those renovations from time to time.
from time to time.
On one occasion, you moved a box of paint thinner under an electrical box.
Yes, I made that mistake. That's correct.
And the defendant reprimanded you for that, didn't she?
Yes,
The defendant said this whole place could go up in one spark.
that's correct.
So she seemed to know that placing paint thinner under an electrical box is dangerous.
Yes,
Well, I'd like to talk about what you saw and what you didn't see on July 31st. You'd agree with me that July 31st, that's the night before the fire. Is that right?
yes,
Like you mentioned, on July 31st, you received a shipment of crates,
that's correct.
multiple crates.
Yes,
You signed off on those crates.
I did.
You opened those crates.
I did.
You noticed those crates contained gallons upon gallons of paint thinner.
That's correct.
You showed this paint thinner to the defendant,
Yes, that's correct.
and when the defendant saw this paint thinner, she looked shocked.
Yes,
She said those weren't supposed to be delivered here.
that's correct. And I can't speak to what you meant by that.
But nonetheless, she told you to put those crates in her office,
Yes,
and you followed through with that.
yes, that's what I did.
That wasn't the last time you saw those crates of paint thinner, was it?
No,
At 6 p.m. on July 31st, you saw Dakota moving crates in the basement.
that's correct.
At 6 p.m. on July 31st, you saw Dakota push those crates right up to the wall.
Yes,
At 6 p.m. on July 31st, you saw the defendant push those crates right under the electrical box.
yes, in the process of moving the boxes around.
You didn't see her move those boxes away from the electrical box.
I did not, but I also did not see her not move them.
So that's a note in my question. You didn't see her take those boxes away from under the electrical box.
No,
Shortly after, Dakota kicked everyone out of the building.
that's correct. After we got the next positive COVID test from the patron.
And you never saw Dakota leave the building after that.
I didn't. I didn't stick around to supervise her.
When you came to work the next day, you stopped by Chuggies.
That's correct.
You saw what remained of Chuggies.
Yes,
Saw the building was reduced to wood remnants and ash.
yes,
You saw billowing smoke emerging from what remained of Chuggies.
that's correct.
When you arrived at Chuggies, Dakota was already there, wasn't she?
That's correct.
Your Honor, at this time, there's no further questions for this witness from the state.
Any redirect?
Yes, Your Honor.
Okay.
Ms. Johnson, you know that Ms. Sutcliffe knows a lot about the fire code.
Objection, Your Honor. Lack of foundation as well as speculation.
Okay, how so?
The question, as phrased, was you know that Dakota knows a lot about the fire code. Further foundation should be laid as to how she would know something that Ms. Sutcliffe knows, as treading into this line of questioning would be speculation.
Your response, Ms. Coleman?
I can simply rephrase, Your Honor.
Okay.
Ms. Johnson, one thing that Dakota is very adamant about is fire code.
Yes, that's correct, as she is a volunteer firefighter herself.
And you also know that placing paint thinner underneath an electrical box is dangerous.
Yes, that's correct.
And yet you saw Dakota Sutcliffe do it one time.
I did.
And you don't know, though, if they could have been moved.
They could have been moved, but again, I'm unsure of that. It is possible.
Okay. No further questions, Your Honor.
Permission to recross, Your Honor?
Yes.
That night in the basement, you saw the defendant moving those crates, right?
That's correct. That's what I stated.
And it was only the defendant that you saw move them right under the electrical box.
Yes, that's what I stated.
Nobody else was handling those boxes that night?
No.
Just her?
Yes.
Nothing further for this witness, Your Honor, from the state.
Any redirect?
No, Your Honor. May my witness please be excused?
Yes. How long do you guys want before closing arguments?
It is currently 10:16, Your Honor. If I'm understanding correctly, both closings are meant to be about 8 minutes or so. Defense is ready to proceed to closing arguments as they are, if the state is ready as well.
Okay.
The state is also ready to proceed with closings, Your Honor.
Okay, then we'll wait for timekeeper to tell us that she's
Prosecution
ready.
has 8 minutes and 58 seconds for their close, and defense has 8 minutes and 31 seconds.
Okay, if we don't take a break, I believe you guys can do that. So prosecution, you may proceed.
All right. May it please the court. Members of the jury, Dakota saw a way out and she took it. Over the course of this trial, it has become abundantly clear that Dakota Sutcliffe is guilty of aggravated arson in that she used paint thinner to cause a fire at Chuggy's on August 1st, 2020, in order to cash out of a $1.5 million fire insurance policy because of the $1 million debt she owed to the bank. Let me explain how we've proved aggravated arson in today's case. Now, Detective Kahn took the stand today and explained that the defendant owed $1 million to the bank via a loan she took out on Chuggy's bar. Now, you already heard from multiple witnesses throughout this trial that the defendant was struggling financially, especially as a result of the pandemic. And yet there was a way out of these financial struggles, namely a $1.5 million fire insurance policy that Detective Kahn testified would have been paid out to the defendant if Chuggy's had burned down. Well, what do you know? Chuggy's did burn down. And now, it was stated during the trial that Dakota did not commit any fraud, and yet, pursuant to Penal Code 18-402, you do not need to find successful committing of fraud in order to find Dakota guilty of arson. It is the purpose to defraud. The fact that there was a $1.5 million insurance policy that could have been paid out to Dakota, and it would have benefited her financially in this case. As such, we proved that element of arson with the intent to defraud. Now, as far as arson in general, how did Dakota do this? Well, Kiran Singh took the stand and testified under oath that the defendant bought 6 5-gallon cans of paint thinner just 2 weeks before the fire. Now, let me remind you that this fire was already determined to be arson, accelerated by paint thinner, the same substance that Dakota bought 30 gallons of. Not just that, but Kieran saw the defendant twice on the night of July 31st. First, at 8 p.m., unloading empty cans of paint thinner into her truck, cans that looked to Kieran to be similar to the ones that he sold to her just 2 weeks prior. And then second, at 11:30 p.m. on the night of July 31st, when Kieran Singh heard a noise outside, went to go check it out and saw none other than the defendant, Dakota Sutcliffe, leaving the area behind Chuggy's. Only 20 minutes after seeing the defendant leaving Chuggy's, Kieran smelled smoke, saw the fire, and called 911. And then you heard from Alex Silva today, who testified as to how he and Jalen Williams fought the fire, and how throughout the course of fighting this fire, that they followed all of the fire code relevant, and that would prove that Jalen Williams was acting in accordance with emergency personnel procedures under the elements within today's case. As such, there's only one person seen leaving Chuggy's 20 minutes prior to the fire, one person who saw a way out and took it, one person who bought 6 5-gallon cans of paint thinner, the same accelerant, and the one person who owed that money and who financially benefited from fire insurance policy. Now, the defense tried to bring in witnesses to counteract this, tried to say that we were short-sighted in our investigation. And yet, within the alleged alibi of Maddox Vaughn, Maddox claimed to see the defendant at the marina the night of the fire, and that it would have been impossible for her to have gone from the marina to set the fire at Chuggy's. And yet, Maddox Vaughn drank 6 to 7 alcoholic drinks that night. Not just that, but she claimed to see the defendant. This person never spoke to Maddox. This person never waved at Maddox. In fact, Maddox saw this person from 70 feet away, and there was no indication that this person even recognized her. Now, with Kieran Singh's identification of the defendant on the night of the fire, he made direct eye contact with Dakota Sutcliffe. Maddox did not. And now Jelani came in and testified that Maddox's testimony was the more reliable one. And yet she did admit that Maddox's testimony may not have been encoded in her memory accurately because of the alcohol that she consumed that night. Meanwhile, Singh's identification of Dakota Sutcliffe, the defendant, behind Chuggy's the night of the fire could not be ignored or discounted. Those are the words you heard from Jelani today. Finally, Tobin came and took the stand and discussed how allegedly Dakota would never do this because of how much she cared about Chuggy's. And yet, Tobin saw the defendant put crates of paint thinner under the electrical box, even after the defendant had previously reprimanded Tobin for the exact same thing. Reprimanded by the defendant, stating that placing paint thinner under the electrical box could cause the whole place to go up in flames. And yet on July 31st, the defendant did exactly what she knew would cause the place to go up in flames. Members of the jury, it is abundantly clear here. Dakota Sutcliffe is guilty of aggravated arson, and in the process of setting this fire in order to alleviate herself from the financial struggle she was dealing with, Jalen Williams suffered. Jalen Williams paid the price. Jalen Williams is dead because of this. Find justice for Jalen and find Dakota Sutcliffe guilty of aggravated arson. Thank you.
Timekeeper, are you ready?
Yes.
You may begin.
Short-sighted. The prosecution's case today is short-sighted. Today, we, the defense, have come before you and shown the absurd conclusions, rampant bias, and the overall incomplete and short-sighted case that the state has brought forth here today. See, the state had to prove beyond a reasonable doubt the highest burden in the land that Dakota Sutcliffe is guilty of all 4 counts of aggravated arson. Reasonable doubt is not a mere possible doubt, but one that guides you in the weighty affairs of life. If you, members of the jury, do not have an abiding conviction of the truth of the charge, then you must find Dakota Sutcliffe not guilty. Let's take these elements one at a time. To begin, the prosecution had to prove to you that Dakota Sutcliffe knowingly created a substantial risk of physical harm to Chuggy's Bar. In order to do that, they had to establish that Dakota Sutcliffe was actually at Chuggy's when the fire was set. See, they brought to you Kieran Singh, and Kieran Singh claims to have seen Dakota behind the bar at 11 p.m. But let's actually be clear about what Kieran saw. See, it was dark outside considering it was so late. And as such, there was not adequate lighting for Kieran Singh to properly see the person that he claimed to have seen. Not only that, ladies and gentlemen of the jury, but Kieran Singh was 40 feet away. And he made eye contact with this person for half a second. Half a second. As Dr. Jelani stated to you, that is not enough time for someone to properly identify a person, even with eye contact. And considering the fact that Kieran Singh saw this person at a distance in poor lighting, it definitely calls into question exactly who he saw. Not only that, it's been established that Kieran Singh doesn't get along with Dakota. See, after Dakota called the cops on him due to his fake ID, he resents her for it. So the person that Kieran Singh claimed to have seen that night was who he wanted to see. But there was someone who did see Dakota on the night of the fire, and that was Maddox Vaughn. And where was Dakota the night of the fire? At the Midlands Marina, an hour away from Chuggy's. At 11:34 p.m., in a well-lit area very familiar to her, Maddox Vaughn saw Dakota. And considering that Dakota was seen at 11:34, and it takes an hour to go from the marina to Chuggy's, there is no physical way that Dakota Sutcliffe could have been there to start the fire. As such, you must find Dakota Sutcliffe not guilty. Now, the prosecution came before you and talked a lot about this paint thinner that was purchased. But what exactly was that paint thinner purchased for? As Tobin Johnson stated, and also Kieran Singh agreed, renovations. See, the back patio wasn't complete. The deck needed to be repainted. Renovations at Chuggy's were not done yet. And they especially were not complete at the time of the fire. We're not disputing that paint thinner isn't an accelerant. We're not disputing that in the context of the fire that paint thinner accelerated that fire. But Dakota Sutcliffe did not use paint thinner for the purpose of starting a fire she wasn't there to commit. That paint thinner was bought by Dakota for the purpose of renovations and nothing more. Not only that, the prosecution also had to prove to you that with Dakota Sutcliffe allegedly setting this fire, they had to do it with the purpose to defraud. The COVID-19 pandemic has been hard on everyone. The Midlands is no stranger. When it comes to how COVID affected Midlands, on March 15th, Governor Walton closed all non-essential businesses, which included Chuggy's. In order to adapt to this, Tobin Johnson became a delivery driver, and Dakota Sutcliffe was determined to sell to patrons the right way. See, that was what it was all along. In order for Dakota Sutcliffe to make money for this loan, she sold to customers. That's all she did, ladies and gentlemen of the jury. And on June 15th, she was able to fully reopen. Now, the prosecution called Noor Khan to the stand. Noor Khan, who they could not establish as an expert in the field that he was hired for, tried to tell you that there were all these mispayments. Let's be clear about something he mentioned. These payments were furloughed, which means that there were no mispayments at all. And in terms of Dakota Sutcliffe's actual financial habits, she overpaid on her taxes. There was no tax evasion. The financial reportings for the bar were accurate. There is no evidence to show that Dakota Sutcliffe committed fraud or engaged in any fraudulent activity at any point in time. And there is no evidence that demonstrates on the night of July 31st to August 1st, 2020, that Dakota Sutcliffe intended to defraud either the bank or the fire insurance company with a fire. They also had to prove that Jalen Williams acted in Dakota's emergency personnel. But as you heard Alex Silva talk about earlier, he was not exactly clear on whether or not there was proper communication. See, he pointed to the bathrooms, but Jalen Williams, it wasn't clear how Jalen responded. Now, let's be clear about something. The fire was not Jalen's fault. Jalen going in to save people, Jalen going in to make sure that he could put the fire out with his partner, that's not on him. His death is not on him. His death is also not on Dakota Sutcliffe. And rather than find justice for the passing of this firefighter, the prosecution would rather point fingers at my client than actually get to the bottom of how this fire actually could have started. Which takes us to the last question. The prosecution had to prove to you that Dakota Sutcliffe set this fire and knew that it would pose a risk to emergency personnel. They came before you and claimed that Dakota Sutcliffe found a way out and took it regarding her financial situation, but that's not the case. See, the way Dakota took was selling to patrons, renovating the bar, appealing to her customer base of college students. No one could reliably ID Dakota at Chuggy's when the fire started. There was no demonstration as to how the fire could have started anyway, considering that you need fire in order for arson to occur. And there's no evidence that indicates any purpose to defraud whatsoever. When you take these factors into consideration, when you look at the short-sighted identification in Kiran Singh, the short-sighted accusation on what the paint thinner was used for, as it was used for renovations, and the short-sighted investigation by this detective, Noor Khan, it's clear that the prosecution's case is so short-sighted that the only people trying to find a way out was them. Find Dakota Sutcliffe not guilty of aggravated arson.
Any rebuttal?
Your Honor, is there enough time for rebuttal based on all loss?
Yeah, all loss was extended because I had computer trouble.
Okay. Thank you, Your Honor.
Okay.
Are timekeepers ready? Timekeepers, let me know when you're ready.
I'm ready.
Okay.
Thank you. Members of the jury, you just heard the defense claim that we did not establish that the defendant was at Chuggy's the night of the fire, and yet we did. The defendant was at Chuggy's the night of the fire because Kiran Singh saw the defendant under street lamps, not, as the defense claims, with poor lighting at all. The defense made such a big deal about the distance between Kieran and Dakota, yet their responding witness with the alleged alibi, Maddox Vaughn, claimed that she saw who she believed to be the defendant from a distance of 70 feet away. That is 30 feet more than what Kieran saw Dakota at, and under the influence of alcohol, no less. Now, Dr. Jelani herself stated that Kieran Singh's identification could not be ignored or discounted, despite what the defense would want you to do with Singh's identification would be to ignore or discount it. And again, between Maddox Vaughn and Kieran Singh, these two witnesses, only one witness, made direct eye contact with Dakota Sutcliffe on the night of July 31st, and that witness was Kieran Singh. Now, moving on to the purpose to defraud. It's true, Detective Khan did not find any evidence of successful fraud committed, but that's not the same. That's not the same as attempt to defraud, because she owed $1 million to the bank and she had a $1.5 million fire insurance policy that would have paid out to her if Chuggies burned down, and it did. The defense claimed that we did not get to the bottom of who caused the fire.
That's time.
Thank you.
Okay. So everyone should go ahead and submit their ballots. Jeffrey, I love that you kept putting up the post the ballots. That was excellent. Any questions? All right. Good job, you guys. I know we're gonna have to watch time better. But I think you guys are doing really well. I saw improvement. Do you guys see improvement? Okay, I'll post my notes up. I won't see you Saturday. I'll talk to Mitchell and talk to you guys on Monday.
Have a good night. Thank
Good
you.
night.
Night. Don't forget to submit your ballots.
Good job. Thank you, Jeffrey.